Similasan.
United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to give their attention, where the court is now sitting. God save the United States and this honorable court.
We will hear argument first this morning in Case 2543, Yellen versus the Confederated Tribes and the consolidated case. Mr. Garnieri?
Mr. Chief Justice, and may it please the Court. Our fundamental submission in this case is that in defining Indian tribe for ISTA purposes, Congress did not deliberately include Alaska Native regional and village corporations, only to then exclude all of them by subjecting them to a formal political recognition requirement that no ANC meets or indeed has ever met. Instead, the settled understanding for the last 45 years has been that ANCs are eligible to be treated as Indian tribes for ISTA purposes, even though ANCs are not and have never been federally recognized Indian tribes. That interpretation has been endorsed by all three branches of the federal government. Congress was acting against the backdrop of those settled understandings when it incorporated the ISTA definition of Indian tribe into the CARES Act in 2020. Congress chose to make ANCs eligible to receive millions of dollars of coronavirus relief funds to benefit the many Alaska Natives whom they serve. The decision below contravenes that policy judgment and threatens to shut ANCs out of a wide range of important federal programs. No sound principle of textual interpretation justifies such a dramatic departure from the status quo. Reading the ISTA definition to mean that ANCs are included only in the event that they are someday, somehow recognized by the United States for government-to-government relations would render their deliberate inclusion in the statute a dead letter. Either the recognition clause must mean something else, or it does not apply to ANCs. Now, we principally urge the Indian Health Service adopted decades ago, and which the Ninth Circuit endorsed in the Cook Inlet case. In our view, Congress defined the entities eligible to enter into ISTA agreements as federally recognized Indian tribes, and also, in addition, the entities that play a similar role in the special case of Alaska, namely Alaska Native villages and Alaska Native corporations defined in and established pursuant to ANCSA. That reading, unlike respondents' reading, gives effect to every word and clause in the statute. I welcome the Court's questions.
Counsel, as I think you confirmed in this opening statement, you rely heavily on the legislative history, the congressional purpose, the post-enactment history. And there was a time when this court also relied on those sources, but this is not that time. And what is the best case you can cite from recent years for your general approach?
Well, I think the case that we find the most instructive is the Court's decision again in United States against Hayes, which is the case discussed in our opening brief. In Hayes, the Court was considering a statutory definition of the term domestic misdemeanor violence, misdemeanor crime of domestic violence. And the statutory definition there had a prefatory clause and then two subsections, and the question before the Court was how to apply a modifier in the second subsection. And based on textual and contextual evidence, the Court concluded that the modifier that appeared in the second subclause of that definition actually applied to its antecedent was one of the words in the prefatory clause at the beginning of the definition. And we think we're asking the Court here for an even less sort of, the interpretation that we're urging here is even more naturally sort of derived from the text than the interpretation the Court adopted in Hayes. And also, to your point, Mr. Chief Justice, I mean, we are making a textual argument. It's not entirely purposive, and it's a textual argument derived from ISTA's definition as well as from the other statutes that Congress has enacted that in their text presuppose that ANCs are eligible to be treated as Indian tribes.
Thank you, Counsel. Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, would you give us again, would you repeat, maybe I missed it, your textual argument again? It seems like it seems, I don't know how you could not have the phrase or clause at the end modifying the entire list.
Well, Justice Thomas, the textual argument is that if you look at the definition of ISTA should not be read to include ANCs in Congress did not deliberately and specifically refer to Alaska Native village and regional corporations established pursuant to a then recent federal law, only to exclude them in the very next clause. We don't think the statute should be read to be at war with itself. And
yeah, but what do you do with the recognized language?
Well, we think that clause, as the Interior Department concluded in 1976, shortly after ISTA was enacted, we think that clause is simply inapplicable to the entities listed in the Alaska clause. And that's really the only reading of, or the reading of a statute that would avoid the glaring superfluity problem that the D.C. Circuit's reading created. Now, of course, as an alternative, we have also advanced in this court the argument that if you understand the recognition clause to apply to the entities listed in the Alaska clause, then recognition cannot refer exclusively to formal federal recognition for government-to-government relations, but must also include the lesser form of recognition that Congress itself bestowed upon ANCs by including them in the ISTA definition.
In the subsequent funding bills, is Congress, with this recognizing that there's been this litigation, has Congress used different language?
Congress has gone both ways on that issue, Justice Thomas. I mean, in the law that Congress enacted, I assume your question is about the recent coronavirus legislation?
Exactly.
Well, in the law that Congress enacted in December of 2020, Congress provided funds for housing programs under a pre-existing federal statute that incorporates in part the ISTA language, and Congress included a proviso there saying that for the avoidance of doubt, that definition includes ANCs. Now, in the most recent law, the America Rescue Plan Act, Congress provided additional funds, coronavirus relief funds, to state and local governments and to tribal governments using the List Act definition, which excludes ANCs. So Congress determined not to include ANCs in that program. And of course, Congress could have done that in the CARES Act. It could have reached for the List Act definition, which everyone understands does not include ANCs, but Congress instead used the ISTA definition, which has been uniformly understood for decades to make ANCs eligible.
Thank you.
Justice Breyer?
I'm just curious as to whether what CARES Act expenditures, necessary related to COVID, et cetera, do the Alaska corporations make that kind of expenditure? Are there examples of where they did or would normally, or where it was necessary? The word necessary is in the CARES Act.
Yes, Your Honor. I think the amicus brief filed by Cook Inlet Region Incorporated, which is the regional ANC covering the Alaska area, goes into that in some detail. I mean, ANCs provide social services to their members, and in the course of doing so, they have and can incur necessary expenditures in response to the pandemic, things like the purchase of personal protective equipment, modifying facilities for safe social distancing.
Okay, I see that. So what's actually bothering me here is I gather there are roughly 150 statutes that definitionally refer to the language, refer to the statute at issue here. Is it the ISCA? That's the statute, right? That has the definition. Okay, I don't know what's in that 150 statutes. I suspect that some of them, it makes sense to apply to the corporations, the Alaska Indian, the corporations, and some it doesn't. So I have a very hard time. Have you been through those? Do we know that the view that you're taking now is going to work in all those 150 statutes?
Well, Justice Breyer, we have reviewed those statutes, and I agree that the ISTA definition is quite frequently appears in the U.S. Code, either by cross-reference or by Congress having used the same language. Now, as we discussed at pages 33 to 34 of our opening brief, there are statutes in which there are other textual and contextual clues that indicate that either ANCs are not included for other reasons, or ANCs, the programs are sort of inapplicable to ANCs.
Yeah.
So I don't,
How do you do that? I mean, that's what I can't quite figure out, because there's an argument, that even if the ISDA applies, the CARES Act doesn't apply. But I don't see, once you say the ISDA, once that definition applies, and it's a statute that really it doesn't make sense to put this kind of corporation in it, how do you read him out of it?
Well, I think in general it's a separate analysis for each statute. I think, one of the most persuasive pieces of textual evidence is, of course, there are instances in which Congress has used the ISTA definition and then has expressly excluded the native village. That really only makes sense if Congress understands the ISTA definition to include ANCs as. All right.
So that's now you've got me where. Thank you. That's really helpful.
Justice Alito?
Mr. Guarnieri, I think you have an absurdity argument, and I'll ask Respondents' Counsel about that. But if you can't prevail on that basis, I can see one textual argument that could possibly work for you, and you make it only in passing, and that is that the clause, which is recognized as eligible, doesn't mean formal recognition in the sense in which Indian tribes are recognized. Do you have any other textual argument?
Well, yes, Justice Alito. I mean, first, we would accept a decision by that court on that alternative ground. But, I mean, as to our principal argument, I think the textual argument is that the word including here functions as a term of enlargement rather than to denote a subset of the specified entities.
Yeah, no, I understand that point. I think that's possible. I don't see how it helps you, because you still have a clause modifying a list, and you want it to jump over the last item in the list. That's really odd, isn't it?
I take the point. Let me try a plain English example to illustrate how we think the ISTA definition works here. I mean, suppose a state were to prioritize for vaccinations all doctors, nurses, and other healthcare workers, including their spouses and minor children, whose jobs require frequent contact with the public. Now, I think in context, one would naturally understand that the final clause in that, the clause referring to jobs requiring frequent contact with the public, really only modifies, and in context can only be understood to modify, the doctors, nurses, and other healthcare workers who appear in the list at the beginning. And then there's just an including clause stuck in the middle there, and perhaps not the most elegant place, but in a place that makes clear that the intent is to expand that category of frontline workers to also include their families and minor children. And that's what Congress did in the ISTA definition. The definition is best read to refer to federally recognized Indian tribes, and then also including, in addition, the specific Alaska Native Village and regional corporations that Congress singled out for inclusion in an Alaska-specific clause.
All right, well, that's very close to what I referred to as the absurdity argument. If we were to take the other possible textual approach and say that recognized doesn't mean formal recognition, what effect would that have in other statutes that use this same definition? Would you be willing to accept that, or would you want us to say this is what it means only in the CARES Act and not in the other statutes in which the same definition is used?
Well, Justice Alito, I think our alternative argument is slightly different. I mean, I think we would say that recognition, on the alternative argument, recognition doesn't refer exclusively to federal recognition for government-to-government relations, but can also refer to the lesser status that Congress conferred on ANCs. And there's a reason I would emphasize that distinction, and it's that, ISTA contracting is not entirely discretionary, and so we do have some concern that other organized groups of Indians who are not federally recognized Indian tribes would be coming in and demanding that the Interior Department engage in ISTA contracting with them.
All right, thank you, counsel. My time is up.
Justice Sotomayor.
Counsel, I'm a bit concerned the way Justice Breyer is about what our ruling would mean here. and it's consistent in part with what Justice Alito has just asked you, which is how do we rule in a narrow way that affects only the CARES Act and not the many other acts that are involved? For ISTA mentioned the Johnson-O'Malley Act, the Schneider Act, which I think is now the Indian Health Improvement Act, and the Transfer Act. But I'm also understanding, I believe, and you can confirm or disaffirm, that there are many other housing assistance, health care, and social service to thousands of Alaskan Natives each year by the ANCs. If we were to accept respondents' position and the D.C. Circuit's holding below, that ISDA cannot include anyone but federally recognized tribes, would we be putting at risk all of those other services?
Well, yes.
And if so, is the federal government prepared to step in and provide those services?
Well, that's exactly right, Justice Sotomayor. A decision affirming the D.C. Circuit here and adopting respondents' construction would call into question the treatment of ANCs under numerous other federal laws that currently provide important federal benefits to Alaska Natives, including housing assistance and energy assistance. And, to your broader point, Justice Sotomayor, I mean, the interpretation that we are propounding here is the interpretation that has prevailed for 45 years, and that was the backdrop for Congress' enactment of numerous other programs incorporating the ISTA language. And so a decision in respondents' favor would threaten to really seriously disrupt the status quo.
Counsel, give us the narrowest ruling that would let respondents win and not put those contracts at risk.
Well, of course, Justice Sotomayor, we think that respondents should not win. I mean, we are here principally.
I respect that, counsel. I'm asking you to tell me.
Sure. I take the point. Well, as between the arguments offered on the other side, a decision finding that ANCs are excluded from receiving CARES Act funds by some specific language in the CARES Act, for example, the definition of a tribal government in the CARES Act, would mean that ANCs are ineligible to receive these particular CARES Act funds, but would not necessarily call into their question their eligibility to be treated as Indian tribes for ISTA purposes under the broader corpus of Indian laws. So certainly a CARES Act specific decision would be a much more narrower ground. The D.C. Circuit here really decided the case on the broadest possible ground. I mean, in this CARES Act dispute, the D.C. Circuit concluded that ANCs have never been eligible to be treated as Indian tribes for ISTA purposes, despite decades of practice to the contrary.
Justice Kagan?
Mr. Guarnieri, would it be fair to say that your textual argument really isn't a textual argument? It's an argument that Congress just made a mistake.
Justice Kagan, I'm not going to sit here and say that this is the best possible way to draft the statute of all of the possible.
Well, I think we can all agree on that. I mean, the question is, you're saying, look, they wouldn't have put something in just to take something out. I understand that. But there's just no grammatical way to read this statute the way you want to read it. No grammatical way, which isn't to say that that's not what Congress intended. I mean, I would have thought that what you're really saying is Congress made a bad grammatical error, but we know what they meant.
I think that's a fair characterization, Justice Kagan. I mean, in Hayes, the decision that I referred to earlier in my colloquy with the Chief Justice, the court described a statute as less than meticulously drafted, and I think we're probably in that category here. But as you said, I mean, I think it's fairly clear what the meaning of this statute was, and that's why.
Well, then the question becomes, is it? Because I think it's a high bar before we're so confident that Congress made a mistake that we just say we think Congress made a mistake, but they meant something else. And that comes to this question of, could they have meant what they appear to mean if you just look at the text, which is that they included the ANCs so that if those ANCs were recognized in the future, they would qualify.
Well, there's just absolutely no hint in the history of ISTA that Congress understood ANCs to be included only on the condition that Congress itself in the future were to somehow decide to recognize for government-to-government relations these recently established and privately owned corporations. We just don't think that that's it's a contextually implausible result.
But wasn't there, Mr. Guarnieri, some uncertainty at the time about what kinds of Alaskan groups would be recognized? I mean, we often say that Alaska is different, and that seems to be the case here, that the government had recognized Native groups without traditional historic bonds. ANCs would have resembled tribes in that they owned land. I mean, we just have sort of different groups here. And why might Congress not have thought, well, we'll see how it all plays out, and maybe one day, given the circumstances of Alaska, these groups will be recognized?
Well, Justice Kagan, the principal consideration going the other way is that for 180 years, one of the core elements of the United States Indian law has been the idea that Indian tribes are possessed of an inherent sovereignty, a sovereignty that is not conferred on them by federal or state law. And that is simply not true for ANCs, and it has never been true, and it would have been apparent to the Congress at the time it enacted ISTA that it was not true. ANCs were established pursuant to a special federal law. They are incorporated under state law, and they are not sovereign entities, and that was evident to everyone at the time.
Thank you.
Justice Gorsuch?
Good morning, counsel. Putting aside what has been called the absurdity argument, and just focusing on the last clause of the text, the recognition clause, and assuming that means something that applies to ANCs. The D.C. Circuit suggested that that's a settled term of art, and it refers to government-to-government relations. What's your response to that argument?
Well, in the lower courts, we also advocated that the recognition clause should be understood to refer to recognition in the formal term of art sense, and that's an important premise for our main argument, which is that the clause, as a matter of context, really cannot be read to include the ANCs. Now, in this court, we have also.
So, am I right in understanding that you think it is a term of art, and that it does refer to government relations?
Yes, certainly language like that has come to be understood as a term of art. It's less clear to us that that would have been apparent to Congress in 1975 when it enacted ISTA. I mean, the precise language at issue here, recognized as eligible, that phrase was not common. It had appeared in perhaps a handful of statutes prior to ISTA, but there was no sort of long.
You got no better solution than to agree that it's a formal term of art referring to government relations.
Well, that's the way that the executive branch has understood it in practice for the last several decades, and we have also understood it not to apply to ANCs. That's the settled construction, and it was the settled construction when Congress incorporated the meaning of ISTA into the CARES Act in 2020.
Thank you.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, Mr. Guarnieri. Just want to follow up on Justice Gorsuch's questions there. I read your alternative argument in the brief, Tad, to say that you agree with the other petitioner that we shouldn't read it as a term of art. So I'm a little confused about what your argument is.
Well, Justice Kavanaugh, it's an argument in the alternative. I mean, our principal argument is that the recognition clause refers to recognition as a term of art or formal, the establishment and institutionalization of formal government-to-government relations, and that's why it cannot be read to apply to the ANCs, because there's simply no sound basis to think that Congress had in mind that ANCs would be included only in the event that they were somehow in the future recognized for government-to-government relations. Now, in the alternative, if the court disagrees with us on that point, then we would argue that a reasonable and certainly a reading that is available to the court is that the recognition clause applies to the ANCs, but that it doesn't refer exclusively to recognition in that term of art sense. Both of those constructions would be far better than the D.C. Circuit's constructions, which rendered the deliberate inclusion of ANCs just a dead letter in the statute.
To pick up on questions I think Justice Breyer, Justice Alito, and Justice Sotomayor were asking about the implications for other statutes, we have a number of amicus briefs saying, for example, the brief of the senators and congressmen saying the potential ramifications would be staggering if your position would not prevail. The Cook Inlet one says it would destabilize the entire tribal health and social services system in Alaska. The brief of the Alaska Federation of Natives says similar things. Do you agree with that, or is there, or not?
We do agree with that. We have grave concerns about what the effects of affirming the D.C. Circuit's decision here would be on a wide range of other federal programs. Now, as a matter of practice, there are relatively few ISTA agreements currently in force, other than the ISTA agreements that the Cook Inlet Region Incorporated, the ANC for the Anchorage area, has to deliver federally funded health care services to Alaska Natives in Anchorage. And, with respect to that specific ISTA agreement, Congress enacted a statute that arguably provides a statutory basis for that separate and apart from ISTA. So we're not entirely sure what the effect of a decision would be on series arrangements, but certainly we are gravely concerned about the destabilizing effect of disrupting what has been the status quo for a very long time.
One last question. How much money is exactly at stake, and what will happen to it if you lose?
Initially, the Department of the Treasury allocated about 6% of this $8 billion fund to the ANCs, which is about $530 million. But as a result of separate litigation, there are proceedings ongoing in district court in DDC right now. As the result of those proceedings, the Treasury is currently in the process of reconsidering the methodology it used to distribute at least a portion of these funds, and that could impact the amount of funds available to go to the ANCs.
Thank you.
Justice Barrett?
Morning, Mr. Guarnieri. I want to go back to the eligibility clause. So you told several of my colleagues that the recognition clause, that one way to understand it is that it's a term of art, but that it has that you could take its ordinary meaning, simply, an entity that contracts with the federal government for services that are designed to go to Indians because of their status as Indians. And you said, well, sure, you can look at this, and I understand it's your backup argument, but you can understand it in its ordinary meaning as the other petitioner advocates for. And then you say, but a lesser included definition would be the term of art recognition definition like we see in the later passed List Act. I don't really see how you can have a lesser included specialized definition. It seems to me either it's ordinary meaning or it's not. And you're kind of cagey in your brief, and I think a little bit at oral argument too, about whether in fact that eligibility clause refers to FRT status. So which is it? I mean, is this the first time that the government has taken the position that language like this doesn't refer to FRT status?
I guess I would put the point this way. I mean, we think that clause can be reasonably read to refer to having a requisite status under federal law, and then it just applies, different entities would be able to satisfy that requirement in different ways. For the ANCs, Congress deemed them to satisfy it by specifically including them among the entities that are eligible to enter into ISTA agreements. For the generic terms listed at the beginning of the statute, that is any Indian tribe, band, nation, or other organized group or community, I mean, the established way for those groups to demonstrate that they have the requisite status is to be acknowledged for government-to-government relations with the United States.
But let me just ask you, that sounds like you're folding back into your argument about, well, specific mention of the Alaskan entities would have not made any sense if the eligibility clause was designed to apply to them, because ANCs, by their very composition, have, they were designed to channel money from the federal government to their shareholders, and so they had that status from the beginning. So what I'm asking you is a little bit different, because if the ordinary meaning, say, of that eligibility clause prevails, then we could rule in your favor without doing this kind of fancy footwork around the awkward grammatical reading of the statute. But you don't really seem to be endorsing that.
Well, we would entirely accept a decision on those grounds. and I don't mean to be dancing around it. Our concern is that, in general, we would hope to preserve the ability to ensure that if the agreements are entered into with tribes or federally recognized tribes that have a kind of recognized status under federal law, and not simply groups that self-identified Indians who come to the Interior Department and demand to take over the delivery of federally funded services. That's why it's important to us as a programmatic matter that, in general, the way that Indian tribes demonstrate that they have the requisite status is through the acknowledgement process, through the process.
A minute to wrap up, counsel.
Thank you, Mr. Chief Justice. I would just like to emphasize again a couple of the points that I've touched on this morning. First, ISTA's definition of Indian tribe should not be read to be at war with itself. Congress did not deliberately and specifically include ANCs in one clause only to then exclude them in the very next clause. Now, our principal argument is that the recognition, if understood as a term of art, the clause should not apply to ANCs, but we would accept the decision under which recognition is given a somewhat more capacious meaning, and the ANCs satisfy that. Second, I just want to emphasize again that the question presented here arises under the CARES Act, which Congress enacted in 2020, and by that time there can be no real question that the ISTA definition was uniformly understood to include ANCs, even though they are not federally recognized Indian tribes. That was the administrative construction. It was the Ninth Circuit's construction in the Cook-Inlet case, the construction articulated in all of the leading treatises in this area. That's the meaning Congress incorporated, and that's the meaning we ask this court to endorse. Thank you, Mr. Chief Justice.
Thank you, counsel. Mr. Clement.
Mr. Chief Justice, and may it please the court, nearly everything about Alaska is different, including its native entities. Congress established ANCs in the Settlement Act as native entities unlike lower 48 tribes. ANCs have never been sovereign, but they have always played a critical role in distributing special federal Indian benefits to Alaska natives. Congress specifically added ANCs to ISDEA's definition of Indian tribes. Respondents, however, contend that Congress accomplished nothing because ANCs do not satisfy the eligibility clause. But if that clause is only given its ordinary meaning, ANCs plainly satisfy it. Congress said recognized as eligible, not recognized as sovereigns, and ANCs have long been recognized as eligible for special federal Indian benefits, starting with the Settlement Act. If instead the phrase is given a term of art meaning restricted to sovereign tribes, then it is wholly inapplicable to entities established by Congress as alternatives to sovereign tribes. Either reading is vastly preferable to one that would defeat the ANC's specific inclusion in the definition.
Thank you, counsel. In your brief, you compare this statute to the case of caretaker being told to feed the cats, the dogs, and goldfish, which are barking. But the force of that analogy comes from the fact that it's impossible for the goldfish to bark. In this case, though, Congress has the authority, right, to formally recognize the ANCs, and so doesn't that undermine your analogy?
I don't think so, Your Honor, because you're right to say that Congress could, in a subsequent act, recognize the ANCs, but that would be a complete departure both from the nature of ANCs and the nature of sovereign recognition.
But you do agree that they have that authority. Congress has the authority to recognize them. In other words, this goldfish can bark.
Well, only if Congress passed a statute that says that when goldfish move their lips, we're going to construe that to be barking, which is to say, it really is impossible based on any understanding of the nature of either ANCs or sovereign recognition to say that the ANCs would be recognized as tribes.
If I end up where Judge Henderson did, and say that the purpose is clear, but the text is also clear, how do I come out the other way? How do you resolve that conflict?
Well, I think the way to resolve that conflict, the easiest way, is to give the eligibility clause its ordinary meaning. It says recognized as eligible. It doesn't say recognized as sovereign. Now, those may be the same thing in the lower 48, but they're very different in Alaska because of the Settlement Act. And so I think that's the way you give meaning to every word in the statute and also honor Congress's evident intent both in 1975 and in 2020.
Justice Thomas?
Thank you, Mr. Chief Justice. Mr. Clement, just some clarification. What's the overlap between the ANCs and the 200-plus tribes in Alaska?
Well, I guess one way to answer that, Justice Thomas, is there's an overlap between the village-level ANCs and the villages. But where there is not an overlap is between the membership and the shareholders of the regional ANCs and the villages. And if you look at just the Anchorage area alone, you're talking about 54,000 Alaskan natives who get benefits from SERI who are not a member of one of the Anchorage area villages, which aren't actually in Anchorage. They're just in the surrounding region.
All right, so are the shareholders of the corporations, the ANCs, are they also members of tribes too? Or are there non-tribal members who are non-tribal individuals who are shareholders?
There are many, tens of thousands Alaskan natives who are shareholders of an ANC, but not enrolled members of any village-type trust. So there's a substantial number of that. Of course, there is some overlap, but once you find that both entities are eligible, there are various ways that it's relatively easy to avoid double counting.
And how would you do that?
You would just make adjustments for overlapping membership. You can also, for some formulas, you use things different other than population. So there's a variety of ways that the Treasury Department actually did it in this very distribution of funds. And more generally, the federal government has found a way to make this work, because what you really do is you do have identifiable native populations, not just in Anchorage, but in Fairbanks and Seward and Valdez, who are not served by any village, but are served by the regional ANC. And those Alaskan natives will go radically underserved if the ANCs are cut out of the statute.
What do you make of the fact that, at least as I understand it, there were no changes made to address the confusion that we have, or the controversy we have in this case, in the American Rescue Plan Act?
Well, I think, Justice Thomas, what's going on there is that essentially Congress didn't want to prefigure how this court would decide this case. So when Congress wanted to include the federally recognized tribes only, it used the LISC Act definition, and when it wanted to include the ANCs, it specified that they were included. But I would say that the understanding from 1975 through the reenactment in 1988 was that the gold standard for including ANCs in the statute was to use the ISDEA definition.
Justice Breyer? With your other argument that you said, well, they're eligible. They're eligible. Mine, that would get us out of this problem. But I'm worried about the other 150 statutes. Have you looked at those? You know, just that kind of definition wouldn't cause a problem somewhere else?
I have looked at those definitions, Justice Breyer, and I don't think it would create a problem in those other statutes. And I guess what I would say is I think the situation is asymmetrical. If there are a couple of statutes, and respondents point to them, that seem to include the ANCs in the statute that is otherwise addressed to some sovereign function that the ANCs really don't discharge. And that modest degree of over-inclusion is really harmless error because they just don't participate in the program. Conversely, there are plenty of statutes that embody the ISDA definition and are plainly involve ANCs and have since their inception. And as the federal government points out in its brief, just in fiscal year 2020 alone, the ANCs received $40 million in housing assistance pursuant to NAHASDA, which basically incorporates the definition from ISDEA. So I think the impact on other statutes is completely asymmetric. If the ANCs fall out because they don't provide the particular program, no harm, no foul. If instead they're cut out of programs they participated in for decades, there are going to be tens of thousands of Alaskan natives who don't get benefits that Congress plainly intended that they would receive, not just in the abstract, but through ANC.
Thank you. Justice Alito?
Is there a difference between your interpretation of the recognition clause and the Solicitor General's interpretation? And if there is a difference, what do you understand it to be?
don't think there is a difference, Justice Alito. I think, as you can see from this morning's argument, though, probably the principal difference is I want to leap to the ordinary language argument, and my friend from the government seems to only want to get sort of edged there. But, you know, I don't think the other side can really have it both ways. You're either a textualist or you're not. And if you're a textualist, why wouldn't you apply the plain meaning of recognized as eligible? Congress said recognized as eligible, not recognized as sovereign. Those may be interchangeable in the lower 48, but they're very different terms in Alaska. And that all goes back to the Settlement Act. Congress didn't want to replicate the lower 48 of sovereign tribes moored to reservations when they distributed the benefits of the land settlement. So they created these new entities that were distinctly Native entities. They caused every Alaskan Native to enroll in one of the regional ANCs. They didn't require them to enroll in a village. And then 4 years later, Congress said, in a process of furthering self-determination, we want to include the ANCs. It would be bizarre to cut them out on the understanding that what Congress really wanted is not to have ANCs play a role in self-determination, but only allow sovereign entities to play a role in self-determination when Congress just rejected that judgment in Alaska.
I'd like you to see if I'm correct on these 2 points. The CARE Act provided a one-time distribution of funds, and at the time when the CARE Act was enacted, no ANC had been recognized.
Recognized as sovereign. I would say they had been recognized as eligible for special federal Indian benefits.
None had been recognized in the sense that the D.C. Circuit thought was necessary. Are those 2 points correct?
Those 2 points are crystal clear.
Thank you.
Justice Sotomayor?
I'm a bit confused, Mr. Clement. What do you see recognized as eligible to mean?
So I see recognized as eligible to mean recognized by the federal government as eligible to participate in special federal Indian programs. And like I said, in the lower 48, recognition and sovereignty go together. But in Alaska in particular, they sort of split that atom, and they created these entities, the ANCs, that are eligible to participate in special federal Indian programs, but they were never understood to be sovereign. And so I think if you recognize that Alaska is different in this regard, then I think that really solves the problem here. And as you yourself pointed out, Your Honor,
I don't disagree with you. I think that it would make no sense to think that ISDA was based on political recognition, but let's get to the CARES Act, okay? How would I see that as relevant to saying that you were recognized to receive money that was being given to governments when ANC are not governments?
Oh, I think that's relatively straightforward, Your Honor, because, yes, the money is being given to tribal governments, but tribal governments is just the recognized governing body of a tribe as defined in ISDEA. And since ANCs are ISDEA tribes and they clearly have recognized governing bodies, there really isn't any statutory problem there. And if it helps, I would point you to 2 other statutes, 40 U.S.C. 502c3, 44 U.S.C. 36018, which are statutes that have a statutory term of tribal government and expressly include ANCs in the definition of tribal government. Somewhat ironically, they include ANCs, but not the villages, in a definition that is specifically directed to tribal governments. So the CARES Act would not be alone in including ANCs in a definition of tribal governments.
Thank you, Counsel.
Justice Kagan?
Mr. Clement, taking this recognized as eligible meaning, when did ANCs become recognized as eligible?
So, Justice Kagan, I think ANCs became recognized as eligible in 1971 in the Settlement Act. Because if you understand that the Settlement Act is distributing the benefits from an Aboriginal land settlement, the traditional thing you would do in that circumstance in the lower 48 is you would give the proceeds to a tribe. But Congress in 1971 understood that Alaska didn't have tribes and reservations the way they did in the lower 48. So they specifically created these entities, the ANCs, to receive the proceeds of the settlement, which I would understand to be special federal Indian benefits. And importantly...
Right, but I mean, Mr. Clement, for sure that act settled land claims. But what does the settling of land claims have to do with eligibility for benefits writ large?
So two things, Your Honor. First of all, they were Aboriginal land claims. So right there, you know these are distinct Native entities to receive distinctly Native benefits. But then the second point I would make, and I think this is important to understand, is Alaskan Natives were eligible in general for special federal Indian benefits even before the Settlement Act through the Snyder Act. And the Snyder Act is one of the acts that is empowered for self-determination under ISDEA. So in a sense, this all works perfectly together. Having just created distinct Native entities that every Alaskan Native was a member of one of the regional ANCs, then Congress in 1975 includes those entities in a statute that's all about self-determination with respect to funds that Alaskan Natives had already, all along, even before 1971, been eligible for.
Thank you, Mr. Clement.
Justice Gorsuch?
Good morning, Mr. Clement. It seems to me that the government is a little nervous about moving off of recognition in its formal sense because it's concerned about self-identifying groups declaring their eligibility for a lot of federal programs. And you're a little less concerned about that, understandably. But there are a couple of terms there that just I struggle with. To the extent we're defining a tribal government, that's what the CARES Act is. Isn't that an odd fit for a corporate board?
Again, Justice Gorsuch, I don't think that it is. And, you know, various Indian tribes, and you probably know this better than I do, are organized in various different ways. I'm sure there are lower 48 tribes that have some kind of corporate incorporation and some kind of board. So it's not like you can't have a Native entity that is governed by a board of directors, which is a very common, ordinary way of referring to it. And as I alluded to in answering Justice Sotomayor's questions, there's at least two other statutes that specifically include ANCs.
Are you aware of other tribal governments organized in this fashion in the lower 48?
I can't point you to one in specific, but I understood.
What about the separate phrase, to Indians because of their status as Indians? Again, that seems like an odd fit for the ANCs, given that, of course, you can be a member of the corporation without being a Native. Today, a lot of alienation has occurred and is permissible.
Well, two things, Your Honor. There hasn't been that much alienation, and anybody who's not a Native doesn't get a voting share. They just get a share. But with that minor clarification, obviously that sort of special federal Indian benefits for Indians is a bit of an odd phrase, not just, I think, it's to ANCs, but to any group, because it really seems to be talking about the benefits that the Alaskan Natives or the lower 48 Natives themselves are eligible because of their status as Indian. But to the extent entities have a status, nobody doubts that ANCs have a Native status. And I think the fact that the real point of the Self-Determination Act is to take Natives who are eligible for special federal Indian benefits, and instead of having the federal government provide those directly, you have a tribal entity do that. And in Alaska, the ANCs have been doing that for 45 years, and it's been working exceptionally well. So there's no basis to disturb that.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, Mr. Clement. I just want to explore briefly your understanding of the term of art canon. Is it your understanding, I think, from what you're saying, that the canon is something of an exception to ordinary meaning? In other words, sometimes you'll look at a phrase or words and say the ordinary meaning is X, but the term of art that we know is Y. Is that your understanding of how it works?
That is my understanding, Justice Kavanaugh, and I do think, as your question suggested, that the strong preference is for ordinary meaning, which is the rule, and term of art is the exception. And in a situation like this, where adopting the term of art reading would create a real problem with the statute, that seems like an obvious case to prefer the ordinary meaning.
And what's your best argument for why recognized as eligible as ordinary meaning supports your position?
Well, I think it's a pretty straightforward argument, Your Honor. I mean, eligibility is not the same as sovereignty. If Congress wanted everything to turn on sovereignty, it would have said recognized as sovereign, or it might have even said eligible via recognition, but it didn't use any of those terms. And one other point I'd like to emphasize is that the term of art argument is much weaker in 1975 than it was after the List Act in 1994. In 1975, as the government's lawyer suggested, recognition is not the well-established term of art that it is. In fact, in 1975, the federal government's recognition process was kind of a mess. When they tried to regularize it a little bit in 1978 with their first regulations, even those regulations talked about acknowledgement. And even today, the federal government has an Office of Tribal Acknowledgement, not an Office of Tribal Recognition. It's really not until 1994 in the List Act that you can really see recognized as eligible as being a term of art. And even then, it's really only a term of art for the lower 48. So making it a term of art back in 1975 that applies to Alaska that would have the effect of frustrating the inclusion of the Alaska Clause really doesn't make any sense.
Thank you.
Justice Barrett?
Mr. Clement, why wouldn't it make sense? I mean, as you just pointed out, the List Act uses language that's identical to the eligibility clause in ISDA. So why then aren't ANCs really practically automatically recognized under the List Act?
Well, they're not, Your Honor, because if you go into the details of the List Act and you go and look at the note to the definition, it's very clear that what Congress was trying to do in the List Act was to essentially force the Interior Department to formalize its process for sovereign recognition. And the ANCs, just based on any traditional criteria for sovereign recognition, just don't come within the terms of that List Act process.
I mean, I understand that, but doesn't Congress's use of that phrase in the List Act undercut your argument that eligibility isn't about sovereignty?
No, I don't think so, Your Honor, and I think, again, for two reasons. One is the language is not exactly identical because whenever Congress has talked about recognition as meaning only sovereignty in subsequent years after 1975, they specifically tethered it to recognition by the Secretary. And I think that brings in the entirety of the process for recognition and its sovereign requirements. And if you go back to 1975, the idea that when Congress was trying to promote self-determination in Alaska, it was going to hinge that on whether the Alaska entities were sovereign doesn't make any sense. Even as to the villages, it took 18 years to figure out whether the villages were sovereign.
I mean, I can see that, but it's kind of at war with the plain meaning of the text if it's understood to be a term of art. And I mean, I take your point that maybe it wasn't a term of art when ISDA was enacted, but became so later, particularly after the List Act. But can you think of any other instance in statutory interpretation where something has had its ordinary meaning in the beginning and then gained a term of art, where then you interpret statutes differently depending on where they fell along the continuum of that process?
It seems to me, I can't point you to that, but I would say two things. One is, if a term only becomes a term of art later, let's say 1994, I don't think you would import it backwards to a statute that was enacted earlier. And I still don't think, even in 1994, that recognized as it's used in ISDA is a term of art. And the best evidence of that is NAHASDA, which was passed 1 year later in 1995. And it basically mimics the ISDA language, and it has been interpreted from day one to include the ANCs, and they got $40 million of funding under it last year.
Thank you, Mr. Clement.
A minute to wrap up, counsel.
Thank you, Mr. Chief Justice. In the end, whether the eligibility clause has an ordinary meaning that ANCs satisfy or a term of art meaning that is wholly inapplicable to them, there is no cause for interpreting ISDA or the CARES Act to exclude ANCs and the natives they serve. Alaska Natives were eligible for special federal Indian benefits long before the Settlement Act in ISDA. Nothing in either statute terminated those benefits or made them turn on membership in a sovereign tribe. To the contrary, the Settlement Act told every Alaska Native to enroll not in a village, but in a regional ANC. As a direct result of that congressional decision, there are tens of thousands of Alaskan natives whose only native affiliation is with an ANC. Cutting ANCs out of ISDEA's definition would leave those Alaskan natives out in the cold. Cutting out ANCs would also destroy Alaska's self-determination success story that depends on cooperation between ANCs and sovereign villages. In short, Alaska is different and Alaska is working. This court should reverse.
Thank you, counsel. Mr. Rasmussen.
Thank you, Mr. Chief Justice, and may it please the court. A unanimous panel of the D.C. Circuit had no difficulty concluding that ANCs do not qualify as Indian tribes under ISDEA and thus under the CARES Act. As the Court of Appeals explained, under basic English sentence construction, the recognition clause unambiguously applies to each of the nouns that precedes it, including each ANC. And by referring to groups recognized as eligible for the special programs available to Indians, the recognition clause plainly refers to the formal recognized status. Indeed, the U.S. agreed with that until this case reached this court. Petitioners contend that the Court of Appeals interpretation would render this statute's inclusion of ANC superfluous. This is wrong for two reasons. First, the cardinal rule is the plain meaning, and the English language construction of the sentence is simple and clear. Second, as petitioners do not even contest, the political branches could, both in 1975 and today, have believed that their plenary authority allowed them to recognize ANCs. Therefore, there is no surplusity problem. Nor is the Court of Appeals interpretation absurd because the court could, or the Congress could reasonably believe when enacting ISDA that ANCs might be recognized in the future. Petitioners also invoke the doctrine of ratification. That is wrong for three reasons, the primary one being simply that that doctrine does not trump the plain meaning. The ANCs warn that left standing, the Court of Appeals decision will deprive Alaska Natives of much-needed services and benefits. In actuality, the opposite is true. Alaska Native villages provide those benefits to Alaska Natives, and the primary example of an ANC doing so, which is SERI, is authorized by an independent statute. The Court of Appeals decision should be affirmed. I welcome the Court's questions.
Counsel, your side's fundamental argument is that the text is clear and that doesn't include, by the time you get to the end of the sentence, it doesn't include the ANCs. But the text itself, in the middle of the clause, does include the ANCs. And then that same clause, under your reading, takes eligibility away from the ANCs. And my question is, why doesn't that text undermine the plain language argument? In other words, we're not talking about some overriding purpose, not talking about legislative history. What we're talking about is the text, and the text says in the list ANCs, and then the text takes away eligibility. And it seems to me that that text creates ambiguity so that a textual reading isn't a plain reading. What's your answer to that?
Well, I think we've got a couple of answers to that, but I think first is that when Congress was acting in 1975, this was completely uncertain. We have from 1971 until 1993 before it became clear. And so there wasn't that certainty. And certainly when Congress was enacting the ISDEA, it did not know. And when Congress doesn't know, this court has never said, oh, well, you've got to go and figure that out, Congress, and you've got to then come up with the decision now when you enact a statute. Instead, what Congress did here is what it commonly does, which is to provide a series and then a qualifier at the end, and that's to include all of the entities that come before that. And so in our brief to this court, we discussed that in the very next section of the CARES Act, Congress does exactly that. It refers to cities, towns, parishes that are over 500,000 people. And Congress, in that case, could have simply looked at a census and said, oh, there's no parish over 500,000. We should take that out. But under the ANC's argument, because it included parishes and then included a qualifier that plainly didn't apply to parishes, all of the parishes should have gotten money.
So I'm not sure I agree with your argument about the uncertainties. ANCs have never had sovereign authority. They didn't at the time. That was the whole point. This was a revolution in the relationship between the national government and Native American governments. These were not governmental organizations. There was no uncertainty at the time. The whole point was that they were not governmental entities.
There was certainly a lot of back and forth on that issue during that period of time. So there were then those attempts. Further, it was also very clear that ANCs could assert, and that Congress, under its plenary authority, could say, we're going to make ANCs tribes. In fact, that has been proposed on occasion. So there's certainly the possibility that ANCs, even if they didn't qualify at that time, Congress could have enacted something under its plenary power later to say that they were. Whether that would then be permissible would be a separate issue for a later date.
Well, why would Congress put ANCs in the language and then take them out? I mean, is your argument based solely on the uncertainty that at some point in the future Congress might undo the whole ANCSA approach based on Alaska's distinct situation?
Well, no, our argument, and perhaps the Chief Justice doesn't agree with it, but we believe that there was substantial uncertainty in 1975. That's certainly what the Court of Appeals found, that there was sufficient uncertainty. When we're dealing with an act of Congress, we don't expect them to be omniscient here. We don't expect them to make that resolution. We expect them to make sure that they cast a wide enough net, and then they use the exclusion clause, the qualification clause at the end, to then eliminate those who wouldn't qualify. And that has the concept that is essential here. And the Alaska Native corporations then don't match that essential concept.
Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, why do you think the Congress did cross-reference ISDA rather than simply the list of recognized tribes?
Well, there are a number of statutes that define Indian tribe that Congress could have incorporated, certainly. Obviously, from the tribe's perspective, we would have rather they specifically incorporated the List Act, but our view is that after 1993, it's clear that the ISDA really incorporates that concept itself, so that there wasn't a problem. Further, in the CARES Act itself, Congress then references the recognized governing body of an Indian tribe. So again, is reiterating that recognition concept in the CARES Act itself, which is why the Ute tribe, the one that I represent primarily, although I'm representing all tribes here today, the Ute tribe views this as something that it would be better to decide this case more narrowly.
Mr. Clement made quite a bit of the broader recognition language in the D.C. Circuit's opinion. And he focused more on the language recognized as eligible language. Would you respond to his argument a bit and what you think is a refutation of his argument?
Well, I think that the primary one is, yes, from 1975 to 1993, there was this uncertainty. 1993 makes that crystal clear that the Alaska Native corporations do not qualify under that qualification that is in the List Act. And therefore, they do not qualify for the same qualification that is within the ISDA. We know that the United States, until now, has been saying that same exact thing all through this case. Now they've got an alternative argument that's no better, but they've been saying that themselves, that they don't qualify.
And what do you make of the ratification argument?
Well, ratification, we as we view it, there are three main issues, and I alluded to one in my opening, which is simply that ratification. This court's decisions are very clear that ratification simply does not trump plain meaning. Also, to have ratification, you would have to have something that is well settled and known to Congress. And we don't have that here. In fact, what we have is a lot of things that, in my view, most of the things are on the other side. They can point to one 1976 memo, and then there's a number of other things that point the exact opposite way. So we don't see how they meet any of the three elements for ratification.
In your brief, you seem to, and I could be wrong, but you seem to make a distinction between Indian tribes and people of Native American ancestry. What difference would that make, if any?
When the recognized tribes, the ones that the United States owes the trust duty to, then establish their membership. And that happens in Alaska as well. And so those are the people that have the trust relationship through their tribe with the United States. So when we're talking about trust responsibilities, that's what we're talking about. So, the ANCs have numerous people who, for whatever reason, are not members of tribes. We agree with Mr. Clement there, but that happens everywhere. There's millions, actually, of people who say they're Native American in the lower 48 who are not members of tribes. That's not an uncommon thing. But this court has always said tribes define their membership, and then the federal recognition establishes the trust responsibilities, and so that's how you have the trust responsibilities flowing to enrolled members of tribes.
Thank you.
Justice Breyer?
Good morning, thank you. Imagine you work for a company that sends people subscription requests. They keep information about subscriptions to vast numbers of publications. And I write back, you get this letter, and you're in charge of filling requests. Dear Mr. et cetera, I would like more information about any newspaper, including the Atlantic Monthly, which is published daily. Would you be at a loss as to how to fill that request?
I'm sorry, Justice Breyer. It became muddled when you were giving me the example.
The example is you get a letter from me or from somebody. It says, please send me more information about any newspaper, on your list, including the Atlantic Monthly, which is published daily. I'm just asking you if you'd have a problem giving me what I want. Is it you wouldn't know what I want?
No, I think in that case you would. I think that's where you get into whether what Congress did here was absurd.
No, it's not absurd. Is my question absurd? Do you have a problem?
No, that's my point. Your question is not. But when you apply that to the ISDEA, and you say, would it be absurd here to do that? Yes, it would be absurd.
I'm just asking if you have trouble filling my request, and I think your answer is no. Very well. Then you take it home, and you show it to your cousin, who is the world's greatest grammarian. And you say, see the kind of bad grammar I get? And he says, you're right to call that poor grammar, bad grammar, but not incorrect grammar. It's not good, but it's far from perfect. And I ask you that only because I've never heard of a canon that says you have to use perfect grammar, or even that you have to use good grammar when you are a member of Congress. What do you think?
Right. Well, I would agree that it's not that we, and the court knows this better than me, we don't expect Congress to use perfect grammar. If we did that in this case, we wouldn't have had a problem if they used perfect grammar. But what we do for the legal analysis is we start from the plain text, from what they wrote down, and what they wrote down is actually clear on the grammar. And then when we get to should there be some reason that we don't apply the plain language, here we would be left with, well, it would have to be so bizarre that Congress could not have meant what it said. We know literally what it said.
Thank you.
Thank you.
Justice Alito?
Mr. Rasmussen, suppose that the definition of Indian tribe in the CARES Act had never been used before. It had not been used in the ISDA. It had not been used in any prior statute. It was crafted by Congress and put in the CARES Act. And the CARES Act provides a one-time distribution of money. And at the time of the enactment of the CARES Act, no ANC had been recognized in the sense that you think is necessary. How then would you account for the reference to ANCs in the definition of an Indian tribe? Would you make the same argument, or would your argument have to be different?
Well, we'd make the same argument that still you'd have the clear language. If you were dealing with something that is going to be a one-time statute, as we are here with the CARES Act, I think that that does change the analysis some, but we would still be making the same argument.
Well, how could you make the same argument? Because then the clause that refers to ANCs wouldn't be surplusage. It would be absurd.
I think that you could say, right, that's where I'm saying I think that the standard they would have to meet here is absurd.
It would be absurd in that case. It would be absurd, would it not?
Only if Congress knew all of that information, right?
Well, Congress didn't know it was making a one-time distribution of funds. Congress didn't know, or we should not presume that Congress was aware that no ANC had been recognized in the sense that you think is important?
Again, I think that you're asking me what our argument would be, and our argument would still be the same. We would, though, have a much more difficult argument on absurdity in that context than we have now.
You would not just have a more difficult argument on absurdity, you would have an impossible argument on absurdity, because you would have a clause that means nothing, that contradicts the meaning that you ascribe to this provision, right?
Well, we would disagree on that, but I can understand where a court would come out with that decision, yes.
Well, how do you disagree? You say that in order to be eligible for these funds, an entity has to be recognized in a certain sense. No ANC had been recognized in that sense at the time when Congress made this one-time distribution of funds. And yet Congress referred to ANCs in the definition of groups that are eligible for these funds. There's a blatant contradiction.
Yes, I would agree in that context there is, and that's why I do think that, I could imagine a court saying that is absurd. I wouldn't say that is absurd because I think, again, the plain language and the complexity of this is sufficient that if Congress wants to, over-include and then use a qualifier at the end to eliminate things, that's how we often draft statutes. We don't go and do that research to find out whether there would be any possibility of an ANC qualifying. The Congress wouldn't do that.
So Congress says any person over the age of 21 is eligible for something. However, nobody between the ages of 30 and 32 is eligible for this. You have contradictory provisions.
Right.
All right, let me come back to my example. Is there any reason why we should not analyze the CARES Act as if the definition of an Indian tribe had been created for that purpose and instead of incorporating by reference a definition that was adopted at a different time? Do you see a difference between those two things?
I see that the CARES Act itself then incorporates that requirement of recognition within itself. That's where our view is that instead of trying to make a broad decision and going on to all these other briefs that discuss all these extraneous issues, we should be looking at the CARES Act itself, which includes that concept of recognition. And we all know what that concept of recognized Indian tribe means.
But you try to escape absurdity by saying that when the ISDA definition was adopted, there was a possibility that ANCs would be recognized in the relevant sense, and at some point in the future, Congress might decide to recognize ANCs in that sense. But when you just look at the time when the CARES Act was adopted, we know that no ANC had been recognized in that sense.
Correct.
All right, thank you.
Justice Sotomayor?
Counsel, we do keep going around in a circle. And the circle starts with the fact that even the government recognizes, and you must too, that in 1974, the recognition clause could not have meant political recognition because that didn't exist at the time. It only existed in the 1990s. So 45 years ago, in 1974, is my math right? When ISDA was passed, there was no term of art that you were recognized as a government body. So now what you're arguing, I think, is that's clear today when the CARES Act was passed, that as Justice Alito just pointed out, then why would Congress have bothered to include ANCs in the CARE Act at all, since after 45 years, it clearly knows now that no ANC has ever been politically recognized. Now I think the government's absurdity argument has more force, because in 45 years, not a one, if we accept what the D.C. Circuit said, that in 1974 it was uncertain whether some would be recognized politically, it's clear now it's not going to be. So don't we have to accept Mr. Clement's argument that ISDA's language as used in the CARES Act cannot mean political recognition?
No, because the CARES Act itself then incorporates that same concept of recognized governing body of an Indian tribe. And so that's where Congress did include that concept within the CARES Act itself. The concept is also within the ISDA, and we now know, I think, that no ANCs are qualified.
That's actually your strongest argument, and I'm going to hope that in its reply, the government will address that question, which is it may not be the case with some of ISDA's uses in other acts like the Housing Act and in other provisions of care, coronavirus care, where that governing body definition isn't included, that one could argue, take up the recognition argument that Mr. Clement has made more clearly. But perhaps then I'll stop now and let the government pick that up later.
Justice Kagan.
Mr. Rasmussen, I agree with you that grammar is very important in understanding statutes, and that grammar often allows us to choose between two possible meanings of a statute. But you have to have another possible meaning for grammar to serve that function. And the question is whether there really is another conceivable meaning here. So you said there is because Congress in the future could have recognized ANCs. Justice Alito said to you it had never done that in the past, but there's something even more than that which seems to make this an implausible understanding, which is that, putting aside whether it's theoretically plausible, I mean, ANCs are just different from the tribes that were recognized at the time. They are for-profit corporations, no historic bonds, members who aren't, shareholders who aren't members of the tribe. I mean, why should we even think that Congress had that in mind as a possibility at the time to make these federally recognized tribes?
So what we have actually is the ANCs themselves saying Congress could do this under its plenary power. Plenary power is very, very broad, and so
I'm not contesting the Congress's legal authority to do it. I guess what I'm contesting is the idea that anybody at the time would have thought that Congress would do it.
Well, there's certainly been efforts to have some of the ANCs federally recognized, at least a few of them, to have them federally recognized. That there has been that effort. To date, those haven't succeeded, but there's by no means certainty.
I mean, suppose I thought that there was a 2% chance that Congress would ever do that. What should I do in interpreting the statute?
Well, I think if we go to 1975, there was a 2% chance. But if we go to today, the whole point of including ANCs is so if that possibility comes around, and they meet that definition, that they then are qualified. They come in basically on an equal footing to all the other tribes. That's why that is in there.
Well, again, if we could just go back to 1975 and ask, was there really any realistic prospect that Congress would have included ANCs as federally recognized tribes? And if I say, it's theoretically possible, Congress has the authority to do this, but if you went around and you polled Congress and you said, do you think of ANCs as federally recognized tribes? They would say, well, of course not. And say I thought that there was an extremely low probability that anybody thought that was, a possibility.
Well,
then wouldn't they just say, well, look, we can, it's a theoretical possibility, but we can put it from our minds, and we can say they wouldn't have included this clause about ANCs if they didn't mean to include this clause about ANCs.
I think that what the example that we use from the CARES Act itself, that Congress does this in statutes. When it casts its net and then it includes the qualifier, it's letting the qualifier do that work for it instead of making those decisions. I mean, if Congress had not included ANCs in that particular act, then it would be saying, yeah, ANCs can never qualify. But it didn't do that. Instead, it gave that as the possibility if they would meet the qualifier.
Thank you.
Justice Gorsuch?
Mr. Rasmussen, first I'd like you to address a kind of a practical question. Your brief expressed concern that ruling for the ANCs would allow a sort of double dipping, that they'd be counted twice for purposes of the CARES Act. Mr. Clement responded to that concern this morning by suggesting that the federal government has lots of ways to administratively ensure that that doesn't occur. If that's right, it's hard to see what we're fighting about here. Can you explain your views?
Well, what we know is that the United States has reserved, I think if I recall correctly from our brief, it's in a footnote in our brief and also in a footnote in Utah's
about
brief.
$530 million.
Well, but about $71 million, if I recall correctly, was allocated to the population of ANCs. And to the extent ANCs have tribal members in them, that is, enrolled Indians in them, those enrolled Indians have already been counted. So there's nothing in the record to explain how the United States came up with this large figure for the population of ANCs, but whatever it would be would either be double counting or would be people who are not Indian, who are not enrolled Indians.
Let me try my question again, though. Mr. Clement says there are administrative ways to deal with that problem, and that therefore we're really fighting over nothing here. Why isn't that correct?
Well, right now I would say it's not correct because when we're dealing with the CARES Act, there is the allocation has already been formulated. But more broadly, to the extent that, again, even no matter where we are, to the extent that there are non-enrolled people of Indian descent, they are not Indians for federal Indian law purposes. And the Indians are the ones that are enrolled in the tribes in Alaska. people who are of Indian descent and can meet the enrollment criteria of any tribe in Alaska can become enrolled in the tribe in Alaska and establish that government-to-government relationship.
Allow me to move to a different set of questions, if I might. The CARES Act speaks of tribal governments, and I asked Mr. Clement, is that an awkward fit with ANCs, for-profit corporations? And he suggested no, that it's entirely possible that Native tribes in the lower 48 could organize themselves in a similar fashion. What are your thoughts about that?
It is a very awkward construction, given that Title V is all about governments, including tribal governments, including the recognized governing bodies of Indian tribes. So we've got this concept of government within that section repeatedly. The money, what we're dealing with here is really, and this goes back a little to your last question, what we're dealing with here is whether that money goes directly to the Indian tribes, who then make the decision whether to provide it to, for example, ANCs who are doing services that benefit their members, or whether it goes to the ANCs directly, cutting out the tribes and eliminating their ability to make that decision. And so in the lower 48, that's exactly what's going on. The money went to the tribes make the decisions. They can get it out to tribal organizations similar to ANCs if they want to, and if those ANCs were providing valuable services. There are a few of them that are, but what we've got here is a decision that every ANC qualifies, and every ANC is going to get at least $100,000, and some of them are going to get tens of millions.
And just to return to a question that Justice Thomas posed, I'm not sure I got the answer to. If effectively this recognition clause asks us to inquire whether the tribe's recognized, why didn't Congress just cross-reference the List Act?
It could have. If Congress, the fact that Congress doesn't...
But it didn't. It cross-referenced a different statute. What should that difference tell us? You're saying nothing. I believe. And isn't that awkward?
No, I don't think it is at all, because I think we now have clarity of what that definition means. And so when we look at the other statutes where that is used, as we discuss, and as the National Congress of American Indians discusses it in depth in their brief, when that statute, that statutory definition is used, it's often very clear that it's excluding ANCs. So we do have some clarity on that. This is a statute that is regularly used when it does not include ANCs, because that's what it means now.
Thank you.
Justice Kavanaugh.
Thank you, Chief Justice. Good morning, Mr. Rasmussen. I want to give you an opportunity to respond to how I think the two statutory arguments on the other side merge potentially. So it seems to me if we start with the text, and we look at recognized as eligible, we have a choice. Do we read that in its ordinary meaning, as Mr. Clement says, or do we read it as a term of art? And that's a choice we have, and we have to figure out how do we resolve that. And one of the ways we usually resolve that is looking at the context to see how Congress might have been using the phrase here. And once we broaden out the lens and look at the context, we see the express inclusion of the ANCs, and we see that they would be left out completely, meaning many tens of thousands of Native Alaskans would be left out completely, not only from the CARES Act, but from many other social services statutes. So given that context, if that's correct, why doesn't that absurdity or oddity or whatever you want to call it help influence the choice we have to make between whether to follow ordinary meaning or term of art meaning for the phrase recognized as eligible?
Well, I think you, in the question, you have bought into a couple of the incorrect statements made by the ANCs in this case. No Indian, no person who is a member of a federally recognized tribe was not already counted when the Treasury divided the money amongst the Indian tribes. So when they're referring to Indians, they're referring to people who are not enrolled in any Indian tribe. They don't have that political relationship with the United States. And they're
those people are Alaska Natives, correct?
They are Alaska Natives.
And why are you treating Alaska Natives as kind of second-class
We're not. This is actually more common in the lower 48 states, that there are numerous people who are not members of tribes who are Indian, that they can be full-blood Indian even and still not be enrolled in a tribe. That's not an uncommon thing, and that can happen in Alaska too. And if those people wanted to enroll in an Indian tribe and they met the qualifications for enrollment in any Indian tribe, they can do that. And then Congress apportioned this money to the governments, and the governments, so the Indian government.
But just to focus again on the question, we have a choice of how to read the phrase recognized as eligible. Mm-hmm. And when we figure out, do we go ordinary meaning or do we go term of art on that? It seems that the express inclusion of the ANCs, and given some of the points that have been made, no one thought that ANCs would ever be politically recognized now or then or in the future. Doesn't that help us choose ordinary meaning rather than term of art meaning here, so as to avoid that oddity, that absurdity, et cetera?
Well, in the ISDEA, it doesn't just say recognized, it goes on to explain what that means. And then in 1993, the United States adopts the List Act and uses that same exact phrase to then say, these are the tribes that these are the entities we're referring to. We're going to list them so that everybody knows. That was what that was designed to do, was to provide that clarity for everybody, and that's what it does.
And on the ratification argument, you said, well, that doesn't apply when there's a plain meaning, but I'm not sure we have a plain meaning, and your argument's really not plain meaning because you're relying on a term of art construction of recognized as eligible.
We're only relying, I view it as certainly the interpretation of the ISDEA, you could use a plain meaning or a term of art meaning in order to get at this answer. What it's using is a term that later becomes the term that is used frequently and that Congress then has the United States define through the List Act and define the members that meet that qualification and meet that definition.
Let me ask one other thing. The amicus briefs from Senators Murkowski and Sullivan and Congressman Young from the Alaska Federation of Natives, from the state of Alaska, from Cook Inlet, they use terms like stunning, egregious, destabilizing, staggering in terms of the effects that an affirmance would have on this program, but also many other programs. Now, they know Alaska. They know how these statutes fit together. The members of Congress from Alaska are appropriately attentive to this. Why are they wrong in describing the consequences of choosing the term of art over ordinary meaning?
Well, I think, I would not question that they know Alaska, but I think they also are motivated by getting $533 million up into Alaska instead of into the mostly into the lower 48 states divided amongst all the tribes. So that's part of what they're doing. But when we look at the record in this case and the examples that they use, those are not accurate. For example, SERI, as the United States forthrightly admits, there aren't very many of these ISDEA contracts in Alaska. You get the exact opposite impression from all of the other briefs by the petitioners and their supporters.
Thank you.
But there are very few.
Justice Barrett?
Mr. Rasmussen, I want to be sure that I understand your position. You told Justice Thomas, and then I think you repeated again to Justice Kavanaugh, that what it takes to establish a trust relationship between a Native Alaskan or a Native American from the lower 48 is enrollment in a tribe. Did I understand that correctly?
The common way of doing it now is enrollment. That it would be enrolled or enrollable under almost every tribe.
Okay, well then what do we make? I'm going to read you this language from ANCSA, and I'm wondering how to fit that in with your theory. It says, Alaska Natives shall remain eligible for all federal Indian programs on the same basis as other Native Americans, notwithstanding any other provision of law. I would take that to mean that because of Alaska's unusual, indeed very distinct, method of handling benefits to Native Americans, that amendment to ANCSA makes clear that that trust relationship exists even though they don't enroll in tribes. Am I wrong about that?
Yes, I would say that is incorrect. That even if you get to Commerce Clause issues, that you simply can't go that far. But
I don't understand why.
Okay, but in the ANCSA, what it is doing is saying on the same basis as others, and that same basis, as we all know now, is enrollment. At the point in time when that happens...
So it's your position that Native Alaskans have no right to any benefits, even though they are automatically put in ANCS if they don't enroll in Alaskan villages, the equivalent of tribes. It's your position that despite this language in ANCSA, they're entitled to nothing from the federal government.
No, it's not our position they're entitled to nothing from the federal government.
As Indians, not as Alaskan citizens or American citizens. I'm saying as Indians, it's your position that they are treated differently if they don't enroll in a village.
No, that is not our position. That many of the programs that we're talking about, so for instance, Nahasda, the housing program, and many of these other programs...
Mr. Espen, I think you're not understanding my question. You asserted broadly that the trust relationship between the United States and a Native person is established when that Native person enrolls in a tribe. And I took you to be saying that the United States doesn't have any kind of trust obligation to a Native person who is unenrolled. And you invoke the example of those who live in the lower 48 who have not affiliated with any tribe. Though those strike me as different because Native Alaskans, it's not just a free-floating group that self-identifies, but are put into as shareholders in ANCS if they choose not to enroll in a village. So I'm trying to understand how to reconcile what you said with this language in ANCSA. And you're referring to other statutes apart from ANCSA.
What I'm referring to is that within the ANCSA, it is saying on the same basis as other tribes, and that then does bring in that concept of, well, if you want to have that relationship, you have to enroll in a tribe. There are 220 tribes up in Alaska, and you have to enroll in one of them.
And it's your position that every Native Alaskan is eligible for membership in one of those tribes? That wasn't my understanding.
No, I don't know whether they are or not. Whether they would be up to the tribes, and there's...
So every Native Alaskan who's unaffiliated with a tribe but is a shareholder in an ANC isn't eligible for benefits as Indians. I mean, it's not just about what intermediary you receive those benefits through or whether you receive them directly from the BIA or another federal entity. You're saying that they are then no different than, say, any other citizen of Alaska that is not Native Alaskan.
Well, I'm having trouble communicating this, but there are other programs that do extend more broadly than to enrolled members of tribes that include people, for example, Nahasda, that includes people who are members of state-recognized tribes. And there are, Nahasda, I believe, includes some similar language that would incorporate...
Let me just shift gears before my time expires, Mr. Rasmussen. You were, earlier in your argument, you were characterizing this as somewhat of a dispute when Justice Gorsuch was asking you about double counting, about who delivers the benefits, whether it's the villages or the ANCS. But isn't this really about whether the lower 48 are allocated more money? In other words, that the primary dispute here isn't about governance or who serves at the intermediary or the ANCS being able to trump how the villages might decide things, but what piece of the pie goes where?
No, our view is that this is a fundamental question about tribal sovereignty, and that the tribes are the sovereigns. Congress was giving the money to the sovereigns for them to make the decision.
My time has expired. Thank you.
Thank you.
Mr. Rasmussen, we have a little bit of time left for any questions my colleagues may have that they didn't get a chance to get to. And I'll start us off. I want to follow up on the questions Justice Barrett and Justice Kavanaugh were asking, because I thought that's what the case was really all about. In other words, there are Alaskan natives who are not enrolled members of a village who receive significant services from ANCs, services that the availability of what is directly impacted by the COVID pandemic. And tens of thousands of people fit that description. And
I understand you're doing what lawyers do, which is trying, to get more money for your clients. But the enrolled members receive those benefits, and if you prevail, I gather, will receive more. But the Alaskan Natives who benefit from the services provided by the ANCs will get nothing. And I just wonder if that's what Congress, and maybe your plain language argument, maybe the answer is that, well, that doesn't matter. But I wonder if there's anybody in Congress who would think that Alaskan Natives receive significant benefits if they're enrolled in a tribe, but not if their benefits are provided through the ANCs. I did not understand Congress to be sort of pushing in favor of enrollment at the expense of participation by ANCs.
That there are significant, programs that are of benefit to tribal members and others who are affiliated with the tribe. That money goes through tribes. Then how the tribes are permitted to spend that money, whether they can provide it to, for example, members of their community who are not enrolled or others, is determined by the specific statutes at issue. There are a number of statutes that certainly permit them to do that. In this particular case, what we have, and that I think that one fundamental problem that we have here is that the actual record in this case only shows 3 ISDEA contracts that are under a separate statute for cadastral surveys. The ANCs own the land, and so the cadastral survey, they have the authority to obtain that money. The only other one we have of record is SERI, and as we've talked about, that has a special statute. So the parade of horribles that they provide of, this is going to deprive people of money or services is simply false.
Thank you, counsel. Thank you. Any of my other colleagues have remaining questions? Okay, you take a minute to wrap up, Mr. Rasmussen.
Thank you, Your Honor. Again, our view is that the plain language is the touchstone. This court has said that repeatedly. The plain language is the touchstone for making these decisions. We don't go to ratification. We don't go to other doctrines when the language is plain. This sentence construction here is very clear, and therefore the court below was correct when it said this is how this case should be decided. Thank you.
Thank you, counsel. Mr. Garnieri, rebuttal.
Thank you, Mr. Chief Justice. I have just a couple of points to make. First, with respect to our primary argument, that is the argument that if the recognition clause is understood to refer to formal political recognition, then it should not be read to apply to ANCs. I think really the pivot point for that argument, as the questions this morning have made clear, is whether you think there was any evidence of uncertainty about the status of ANCs when Congress enacted that language in 1975. And neither the Court of Appeals nor respondents have ever identified any evidence that Congress was at any time uncertain about the sovereign status of ANCs. And there's textual evidence in ISTA to that effect. I mean, the ISTA definition recites that ANCs were established pursuant to ANCSA. So it's entirely implausible to think that Congress itself was uncertain about the sovereignty, or I should say lack of sovereignty, about these corporations that Congress itself had established in a then recent federal law. Certainly, there was no doubt about that point in 2020 when Congress enacted the CARES Act and incorporated into it the ISTA definition. And as I think Justice Alito's perceptive questions have pointed out, I mean, it makes no sense to think that the CARES Act incorporated, for purposes of a one-time distribution of funds, the CARES Act incorporated a definition under which ANCs would be included only if, at some theoretical point in the future, Congress chooses to fundamentally reinvent the concept of recognition and recognize as eligible for government-to-government relations these private corporations. Now, the second point I want to address is the CARES Act language about the definition of a tribal government. The CARES Act defines a tribal government in terms that are almost word-for-word identical to the definition of a tribal organization in ISTA. And as the district court explained at pages 68A to 70A of the appendix, ANCs have long been understood to have a recognized governing body for ISTA purposes, and so too they have a recognized governing body for CARES Act purposes. Now, third, with respect to our alternative argument, I mean, Mr. Clement has ably addressed that argument, and I would just add that, our point is simply that it's possible that different entities could demonstrate that they are recognized as eligible to participate in ISTA contracting in different ways. For the lower 48 states, the paradigm is acknowledgement by the federal government. But for ANCs, Congress has already deemed them to be eligible by including them in this special Alaska clause in the ISTA definition. And then finally, on the practicalities, I mean, many thousands of Alaska Natives are not enrolled members of a federally recognized Indian tribe, and that's by design. I mean, that's how Congress set it up in ANCSA. And a decision finding that ANCs are ineligible to receive these CARES Act funds and potentially ineligible to participate in the many other federal programs that rely on the same language as the ISTA definition would have serious consequences for the delivery of federal services and benefits to Alaska Natives. It would disrupt the status quo that has prevailed for decades, and we ask this court to reject that interpretation and to reverse. Thank you.
Thank you, counsel. The case is submitted. We will hear argument next in case 2315, Sanchez versus Mayorkas. Ms. Saharia?
Mr. Chief Justice, and may it please the court. TPS recipients satisfy the admission requirement for adjustment to lawful permanent resident status. That is because Section 1254A-F4 considers TPS recipients to be in lawful status as a non-immigrant for purposes of adjusting status, and having been admitted is inherent in non-immigrant status. The government's view that admission is not inherent in non-immigrant status is untenable. The INA distinguishes between categories of persons who are admitted and those who are not. Some persons with lawful status, such as asylees and parolees, are not admitted. individuals in non-immigrant status are admitted. As the DHS policy manual states, a non-immigrant is a person who is admitted for a specific period of time. The INA's express exception for non-immigrant crewmen demonstrates that unless Congress makes an exception, admission is inherent in non-immigrant status. The government's primary response is to argue that the statute considers TPS recipients to be in lawful status but not admitted. But if Congress intended only that limited function, it need only have said that TPS recipients are considered to be in lawful status, period. The function served by the additional phrase, as a non-immigrant, is to ensure that TPS recipients are considered admitted just as all non-immigrants are. This is the only sensible reading of the statute. TPS recipients are subject to rigorous scrutiny and risk removal by coming forward and registering. In exchange, Congress made them eligible to adjust status if they acquire a qualifying relationship, assuming they meet all the statutory requirements, which not all will. By contrast, the government's interpretation would shrink the pool of eligible TPS recipients to the few with non-immigrant status before they receive TPS. There is no warrant in the text for that result. I welcome the court's questions.
Counsel, as I understand your argument, it's that people in non-immigrant status go through a process to get there that includes admission and inspection. And there's another way to get to non-immigrant status, and that is by being a TPS recipient. And your argument seems to me to be that, well, if you're in non-immigrant status as a TPS recipient, you must have been admitted and inspected or treated as such, because that's the other way to get to non-immigrant status. And I wonder why they're just not two different routes, and if you come in one route, the TPS route, that doesn't mean that you've checked every box to get in through the other route. So it seems to me that I can't follow the logic of your main submission.
So I don't think that is an entirely accurate characterization of our position. Our position is not that TPS recipients are in non-immigrant status. It's clear that they are not for all purposes. Our position is simply that F4 considers TPS recipients to be in lawful non-immigrant status for just one purpose, that purpose being adjustment of status. And importantly, the only characteristic of non-immigrant status that is even relevant to adjusting status is the fact that non-immigrants are inspected and admitted.
Well, but usually, I mean, there are other places where Congress deems people, when they want to get to that same status, to have been admitted and inspected. And therefore, you would say, well, they should be regarded as having checked that box when you're determining parole and other situations. But that's not what the statute does here. It doesn't say that you are deemed to have been admitted and inspected. It says that you have non-immigrant status.
That's because that particular formulation would not have achieved all of Congress's objectives in F4. For example, deeming TPS recipients simply to have been inspected and admitted would not have permitted TPS recipients to change to non-immigrant status under Section 1258, and we know Congress intended that as well because it cross-referenced Section 1258. The beauty of what Congress did was to choose broad language that achieves multiple different objectives in F4, and that's why that narrow formulation is not what Congress chose.
Thank you, Counsel. Justice Thomas?
Counsel, what's your argument is that the status, the non-immigrant status, necessarily entails inspection. Do you have a case for that?
Yes, Your Honor. The case that states that is a decision by the board in a case called Garnica Silva. I will confess it is unpublished, but it's exactly on point. In that case, a non-immigrant who received their status from inside the country as a U visa non-immigrant argued that he was not admitted, and the government and the board both agreed that, of course, he was admitted because all non-immigrants are admitted.
Could you elaborate on what it means to be admitted in that case?
Yeah, so the question in that particular case was whether that particular person was deportable as someone who had committed a crime within a certain period of admission. And so his position was, because he had not received his non-immigrant status at the border, he was not deemed to have been admitted as that term is defined in the INA. But the government and the board disagreed with that position, and as they explained, the INA consistently treats all non-immigrants, except for alien crewmen who are accepted, as having been admitted. That is the defining characteristic of non-immigrant status, is the fact that they were admitted into that status. And so in that case, the board held that unlike asylees, for instance, who are not admitted, non-immigrants are admitted.
But in the case of petitioners, how does that work? Because they clearly were not admitted at the borders. So is that a fiction? Is it metaphysical? What is it? I don't know. Where do we get it? Just from the definition, we assume that if you gain a certain status, you assume that, for the purposes of gaining that status, you must have been admitted. But we know for a fact that's not the case. So what do we do with that?
Well, F4 uses considering language, which is the language that Congress typically uses when it wants to create a legal fiction. And the legal fiction that Congress created here is that TPS recipients are deemed to be in lawful non-immigrant status for the purpose of adjusting status. And again, the characteristic of non-immigrant status that is relevant to adjusting status is the fact that they are inspected and admitted. That's why non-immigrants can adjust status at all under Section 1255A, even though the word non-immigrant does not appear in that provision. It's because the words inspected and admitted are describing non-immigrants.
Thank you.
Justice Breyer? Well, I have to admit that the immigration statute is pretty complicated. So is there a simple way of explaining this? I mean, I look at 1255 and it says if you want to change to your permanent resident, if you want to change to be a permanent resident or something like that, you have to have been inspected and admitted, which your clients weren't. And then we look over here at the temporary protected, and it says during a period where you're granted temporary status, you do have lawful status as a non-immigrant. It's during that period. It doesn't say anything about it. You could apply. But you say, well, the word non-immigrant automatically means admitted. So we look through some of this, and, for example, the U visa holder, the statute says they can apply if they were admitted or otherwise provided non-immigrant status. Now, that seems to say admitted is one thing. Non-immigrant status may sometimes include that, may sometimes not. I mean, so help me.
Sure. So with respect to two responses with respect to the U visa holders. Number one, they didn't exist in 1990 when Congress passed this statute. So even if it were true that there is some category of non-immigrants who are not admitted, that came about later. That could not have informed what Congress was thinking in 1990. But more fundamentally, I would again point the court to the decision that I cited before, which is the matter of Garnica-Silva case. Because in that case, the immigrant cited the very language that Your Honor just pointed to, and the government said, no need to worry about that language. That language simply explains that someone may already be admitted as a non-immigrant in a different classification and then change into the U visa status classification under Section 1250.
I see that, but look, to me at the moment, it seems to make sense to say either. I mean, you could say, you're here, Mr. Smith. Mr. Smith, you came in absolutely illegally, absolutely wrong that you're here, but you're here. And if you're here, we're not going to ship you back to a place where you're really in danger. Okay? Well, you're in danger. But once that's over, goodbye. That's a way of looking at it. Or it could have meant, well, we want to keep you here. Once you're here and you're in a terrible situation, you might have been here for a long time. Some who were here for a long time, the Attorney General could say, okay, we waive all that, I guess. but it could mean either.
Well,
so what do we do? I mean, how strong is this argument? It must automatically mean.
Well, it's very strong because there's no other logical interpretation of what Congress was doing in.
Yeah, the logical interpretation is what I said. They said, Mr. Illegal Alien, illegal person, you came in illegally, okay, we won't ship you back yet because there's a big war or something in your country. But when that's over, you're over here. Why isn't that logical?
Well, because Section F4 exists in the statute, and it has to have a purpose. And the government's interpretation gives no purpose to the words as a non-immigrant in F4. Those words are critical because Congress would have understood clearly from the INA in 1990 that non-immigrants are...
Well, you say that. That's why I'm back at my original question. You say, well, it must mean admitted. Well, it didn't in the U visa case because they had both things separately. So there must be some way of becoming a non-immigrant here lawfully, where you were not automatically admitted lawfully. And here it is, right in our statute in front of us, and also in the U visa case. Anything else? I mean, why is that so far off base? Explain that to me. I'd like to know.
So again, the U visa category did not exist in 1990.
So what?
Justice Alito?
Well, here's another example along the same lines. Section 1255M refers to, quote, an alien admitted into the United States, or otherwise provided non-immigrant status. Why doesn't that mean that Congress contemplated that one could be in a non-immigrant status without having been admitted to the United States?
Well, Justice Alito, that is the very same language that I was just discussing with Justice Breyer. Section M applies to U visa holders, and this section, number one, did not exist in 1990, but number two, as the government explained to the board in the Garnica-Silva case, that language simply refers to the possibility that someone could obtain U visa status by changing to that status after already having been admitted into a different status. And it was important for Congress to use those words here because this provision sets forth special procedures for U visa immigrants to adjust status. And so Congress needed to make clear that whether they receive that by being admitted into that status or whether they receive that status by changing into that status, they would be eligible for these special procedures.
Would you agree that if Congress did in F4 what you say it did, it went about it in a very roundabout way? It specifically addressed two of the requirements for eligibility for adjustment of status, namely being in and maintaining lawful status as a non-immigrant, but it didn't say anything about inspection or admission. Why would it do that?
Well,
why would it leave it to the courts to infer that lawful status as a non-immigrant necessarily means inspection and admission?
Well, because Congress used broad language that both accomplish its objectives with respect to 1255A, but also accomplish its objectives with respect to 1258 and 1255C2. And I think it's critical that under the government's interpretation that F4 simply was intended to overcome C2, that interpretation renders the words as a non-immigrant superfluous. And that is because under Section C2, multiple forms of lawful status can satisfy that provision. Some of those forms of lawful status, such as asylum, do not require admission. But Congress chose a form of lawful status, non-immigrant status, in which admission is inherent. In the same way, for example, that having been paroled is inherent in parolee status, having been inspected and admitted is inherent in having non-immigrant status.
In a footnote in your brief, you assert that your clients were paroled into the United States. Does that satisfy 1255A?
It does satisfy 1255A, but it does not satisfy Section 1255K, which petitioners need to satisfy as employment-based applicants.
Thank you.
Justice Sotomayor?
Counsel, I'm sorry, I'm lost. Aren't asylum, people who receive asylum, they're not admitted, but they're in non-immigrant status, aren't they?
No, they're in asylee status. They are not in non-immigrant status.
But the crewmen are in non-immigrant status.
That is correct, and that's why for crewmen, Congress had to create a special statutory exception because the default rule in the INA is that persons with non-immigrant status are admitted.
One of your other arguments is that Section 1254AF4 provides that CPS recipients should be considered as both being in and maintaining lawful status as a non-immigrant. And you're right that usually we hesitate to interpret a statute in a way that would make any of its provisions inoperative or irrelevant. In the case of being in, however, the government responds that being in parallels Section 1255C2 bar on an applicant who is in unlawful immigration status, while the maintaining parallels the separate bar on an applicant who has failed to maintain continuously a lawful status. Your reply brief did not comment on the government's argument, because it is a way to understand that there's not a superfluous argument. So would you comment now and explain why the government's wrong?
Sure, two reasons. Number one, the government's argument that the language of Section F4 simply tracks the being in and maintaining language in C2 overlooks the words as a non-immigrant and gives no effect to those words. But with respect to the being in and maintaining language in particular, the government's position is that the only people who benefited from this provision when it was enacted are people who were already in lawful non-immigrant status. And for those people, the word maintain does all the work. It satisfies both the being in and maintaining language in C2, and that is why when Congress wrote other contemporaneous provisions, including in this rejected Senate version of this very act, and it expressly limited the adjustment of status benefit to persons who were already in lawful non-immigrant status, as the government claims this provision does. Congress used only the word maintaining. The government has given no effect to Congress's obvious choice to use broader language in F4 and to omit any restrictive language restricting the benefit of F4 to persons already in lawful non-immigrant status.
Thank you, counsel.
Justice Kagan?
Mr. Harry, you say in your brief, and I think this is critical to your argument, all persons with lawful non-immigrant status are by definition inspected and admitted. If that's not true, can you still win this case?
No, I don't believe so.
Okay. So what makes that true? I mean, you say by definition. I mean, I want to look to some statutory language that tells me that that's true. Where am I supposed to look?
Well, I think you would look to Section 1184 of the INA, which is the section that authorizes the government to confer non-immigrant status on individuals, and that statute refers to that process as admission.
Well,
and there is
but there's nothing in that section, is there, that says, that reads, that stands for the broad proposition that you're stating? I mean, the section says the admission to the United States of any alien is a non-immigrant, but why does that suggest that admission is something that all non-immigrants get?
Because there's no other mechanism in the INA for the government to confer non-immigrant status on individuals. It is the only mechanism, with the exception of the one category that is accepted, which are alien crewmen. That's why the INA over and over and over again describes non-immigrants as admitted. And even
I mean, you yourself said 1255M suggests something different, and you said, well, we shouldn't look to that because it was passed afterward. But just the fact that 1255M could have been written without saying something like, notwithstanding Section 1184 suggests that there's no rule of the kind that you're talking about in the first instance.
I would point the court again to the board's discussion of that very language in subsection M, where the board reviewed the INA and the regulations governing U visa recipients and other non-immigrants, and the board said, considering all of that, the statutory text and the regulatory text, that non-immigrants are admitted, and that language only was referring to the fact that someone could change into that status after already being admitted in another kind of status.
Thank you.
Justice Gorsuch?
Thank you, Chief. I have no questions at this time.
Justice Kavanaugh?
Thank you, Chief Justice. Ms. Zaharia, good morning, good afternoon.
Good afternoon.
And I think the questions my colleagues have pointed out and Judge Hardiman's opinion in the Third Circuit point out that you have an uphill climb, textually speaking, and I guess more broadly, I guess that raises the question for me of we need to be careful about tinkering with the immigration statutes as written, particularly when Congress has such a primary role here. Congress, as I understand it, passed a recent bill, the House, I should say, passed a recent bill on this issue. It obviously has not passed the Senate yet, but just kind of big picture, why should we jump in here when Congress is very focused on immigration and when you're relying, in putting forth a good argument, but relying on chains of inferences rather than specific language, as I see it at least?
Well, because respectfully, we are relying on the specific language of F4, and that specific language is that TPS recipients are considered to be in lawful status as a non-immigrant. Again, the government cannot give any effect to those critical words in the statute. If Congress intended only to do what the government claims it was doing, it need only have said that TPS recipients are being in and maintaining lawful status, period.
Don't you think the flip side also applies, though, if Congress was intending to do what you want? Seems almost certain there would be more explicit language.
I don't think that's the case because Congress used broad language that both satisfies Section 1255A but also satisfies Section 1258.
And what is the status in Congress? Are you aware?
I'm not aware, Your Honor, of what is the status in the Senate, but it's not surprising that Congress would seek to clarify this issue given the existence of a circuit split on this question.
Thank you very much.
Justice Barrett?
Good morning. So I have a question about 1254AH. So it seems to me that provision cuts strongly against your position because that provision requires Senate supermajority support to approve any legislation that provides for adjustment to lawful, temporary, or permanent resident alien status for any alien receiving TPS. So if Congress tied, or the Senate, in the bill that Congress passed, has tied its own hands in that way, it would seem unusual that in the same breath, by using non-immigrant status, Congress intended to delegate to the executive much broader authority to treat TPS, those in TPS status as eligible for LPR status based only on the word non-immigrant. Could you address that?
Sure. So both parties agree that F4 allows some TPS recipients to make use of the existing mechanism for adjusting status, and subsection H just doesn't say anything about which ones. Subsection H only tells us that Congress wanted to make it more difficult for a subsequent Congress to establish a new standalone mechanism for TPS recipients to adjust status, and that makes sense because Congress had done that in the past where it would take broad categories of people and make them automatically eligible to adjust status. And so Congress, yes, did tie its hands with respect to creating a new mechanism, but Section F4 doesn't create a new mechanism. It just gives otherwise eligible TPS recipients access to the existing mechanism in Section 1255.
The government's interpretation does give F4 work to do because, those who were in lawful status before, for example, if they overstayed student visas, but then became eligible for TPS status, that overstaying is forgiven if there was a gap. Or similarly, if they got TPS status while in lawful non-immigrant status holding a student visa, F4 still helps and cures those
obstacles to becoming an LPR. Could you address that?
Yes. S4 is an odd way to accomplish that very narrow purpose, given that it applies on its face to all TPS recipients, and given that Congress knew that the first TPS recipients included hundreds of thousands of individuals who had entered the country unlawfully. It's also an odd way to write that provision, given that the Senate version of the Act contained that very provision that the government claims this does, but on its face, that provision was limited to people who were already in lawful non-immigrant status.
Thank you.
A minute to wrap up. Ms. Zaharia?
Yes. Having been admitted is inherent in non-immigrant status in the same way that having been paroled is inherent in parolee status. If Congress had stated in F4 that TPS recipients should be considered as being in and maintaining parolee status for purposes of adjusting status, no one would question that Congress intended for TPS recipients to be considered to have been paroled for purposes of adjusting status, because those two things are the same. The same is true here. Having been admitted is inherent in having non-immigrant status, and it is the only characteristic of non-immigrant status that is relevant to adjusting status. Congress's choice to consider TPS recipients as being in non-immigrant status as opposed to some other form of status means that they are considered to be inspected and admitted for purposes of adjusting status. Thank you.
Thank you, counsel. Mr. Houston?
Mr. Chief Justice, and may it please the court, an agency does not act contrary to law when it interprets a statutory term in accordance with its statutory definition. For petitioners to be eligible to adjust to lawful permanent resident status, they need to show, among several other things, that they were admitted into the United States. But admitted is a defined term in the INA, and petitioners concede that they do not meet that definition. They did not make a lawful entry into the United States after inspection and authorization by an immigration officer. Petitioners instead contend that Congress implicitly deemed TPS recipients to be admitted by giving them lawful status as non-immigrants. But the TPS statute's two-part lawful status benefit directly tracks the two-part lawful status requirement for adjustment of status. The TPS statute does not address the multiple other requirements for adjustment of status, such as admission. And that's confirmed by the fact that that the lawful status benefit is available only, quote, during the TPS period, which strongly suggests that it does not retroactively cure pre-TPS conduct that made the person ineligible for adjustment. Petitioner's argument by syllogism collapses because nothing in the INA defines non-immigrant status to necessarily include admission. And more fundamentally, petitioner's argument relies on implications and an unstated cross-reference, but Congress does not make unambiguous exceptions to statutory definitions in such circuitous ways. And that is particularly true in this statute, where Congress did create several express exceptions to the various requirements for adjustment of status, but did not provide any comparable exception for TPS recipients. TPS offers temporary protection against removal during a crisis, and it preserves the existing opportunities of previously admitted non-immigrants to adjust their status. But USCIS reasonably determined that Congress did not establish TPS as a special pathway to permanent residence for non-citizens who were already barred from that privilege because of pre-TPS conduct.
Mr. Houston, I was struck by the extent to which your brief undersold your position. Throughout it, you said things like the text doesn't foreclose your position, the court was not required to accept the petitioner's reading, the statute does not clearly exclude your reading, Congress did not unambiguously mandate the opponent's position, and of course you ended by saying that it would not be entirely unreasonable for the court to rule in your favor. I made that last one up, but that's what I was expecting to see. Do you want us to say that your interpretation of the statute is the correct one?
Your Honor, we think that the court should follow its precedents in the immigration area, particularly Martinez-Gutierrez, which has indicated that when an agency, as in this case, has consistently interpreted the statute with the force of law, the agency's position prevails if it's a reasonable construction of the statute, and the court has no need to decide whether there's any other construction that would be possible. I think that's what the court's precedents dictate as the analytical approach to these types of cases, and we just think the court should follow that here.
Well, did you think that at the cert stage? Because in your response to the petition for cert, and this is a quote, the Court of Appeals reading clearly represents the best one in light of the statutory text, structure, and context. Is that still the department's position, that your reading is clearly the best one?
Your Honor, we absolutely contend that the government's position is the better reading of the statutory text. And even if the court was not inclined to apply Chevron deference, the result would be the same. We think our interpretation is the better one. All we're saying is that we don't need, in this case, to show that there is no other interpretation. And as I think petitioners have acknowledged in their brief, in order for them to prevail, they need to show that the statute unambiguously forecloses the government's position. And our respectful submission is that they can't clear that high bar.
Justice Thomas?
Thank you, Mr. Chief Justice. Counsel, as a matter of curiosity, if the petitioners here were allowed to leave the country for a brief visit abroad and return, would they then be eligible for adjustment of status?
Not under the government's current interpretation of the statute, Justice Thomas, although the government announced that interpretation in a case in a decision called INRI CRZC in 2020, and it did not make that decision retroactive to people who had traveled before 2020.
So the argument that petitioners make that inspection is implicit in the status as a non-immigrant, it seems to be quite reasonable. I mean, how else would you categorize someone as a non-immigrant under these statutes other than assuming that they have been inspected or that they have been deemed to be inspected?
Justice Thomas, the non-immigrant statuses are defined in the INA at 8 U.S.C. 1101A15, but nothing in that provision states that it is a condition of receiving one of those non-immigrant statuses that you were necessarily admitted. As I think petitioners have recognized throughout this case, admission and lawful immigration status are distinct concepts. Your immigration status refers to your permission to be present in this country, and as I think the example of alien crewmen demonstrates, there's nothing in the INA that bars Congress from saying to a particular group of people, you will have the status of non-immigrants, and that's exactly what Congress says to persons who come here as crewmen on foreign vessels while they are here. They make a lawful entry, so they would seem to fit the definition of admitted, but Congress says you are lawful non-immigrants, but you are not admitted. There's nothing in the INA that forecloses that because admission is not a constituent part of what it means to have non-immigrant status.
Well, why couldn't the designation for the crewman be considered an exception to the general rule?
The reason why that exception for crewmen is in there, Justice Thomas, is again because alien crewmen they do make a lawful entry. They of course come here lawfully on their vessel, and when that vessel lands, so they would seem to fit the ordinary definition of admitted. So I think it makes sense that Congress would clarify you are not admitted while you are here for the purposes of staying, until your vessel departs. I think that's just a perfectly sensible thing to do. But the broader point is that when you look at the various non-immigrant statuses that are described in Section 1101A15, you will not see anything that says the person, in order to have this status, must necessarily have been admitted. We simply use the admission process to bring in people who come here lawfully from overseas, but that's not part of what it means to have non-immigrant status.
Thank you.
Justice Breyer?
Well, following on from Justice Thomas, I take it the argument of the petitioner is simply this. You look through the United States. Look everywhere. everywhere, every tunnel, every mountain, every lake, every human being you come across who is not, etc. If they are non-immigrants and they are here lawfully, they are here as non-immigrants, they will have been either deemed to be or actually been lawfully admitted. So it goes along with the game. There we are. But I admit there are two exceptions. One's crewman, where they use both terms, and that could just be overinsurance because they wanted those people admitted. And the other is the U visa. And the U visa, they could have been trying to do uncertainty. Okay? So doesn't that are there other examples that I've missed? That's my main question. Other examples that I've missed. And if there are no others, then aren't we in the world where there is ambiguity in the statute, and we have to get into the Chevron issue, which, as you well know, is a big issue, where there are two sides, and should this be the case where we get into that? All right, both questions.
Justice Breyer, I don't think there are any other classes of non-immigrants who are not admitted, but importantly, one of the key reasons for that is that there are certain kinds of non-immigrants who receive that status within the United States after an unlawful entry, and those people, of course, would not meet the statutory definition of admitted in the ordinary case. But in some cases, Congress has nevertheless labeled those classes of non-immigrants as admitted, and of course, Congress is free by context to change the meaning of admitted, and it's done that a couple of times. And as you note, I think the U visa example shows this too. Congress has specified that U non-immigrants are eligible to adjust their status, whether they were admitted or otherwise acquired that status. So we think that it is not necessary for the court to get into Chevron deference here, because we simply think we have the better interpretation of the statutory text. If the court was inclined, if the court thought that the statute is ambiguous, I think that the combination of various sources where the government has consistently interpreted this statute the same way that we do since 1991, in a decision by the Board of Immigration Appeals, in a decision that was approved as lawful by the Attorney General, and in a response to notice and comment rulemaking, all would make the case for deference very easy.
Justice Alito?
Would it be reasonable to interpret the statute the other way?
Well, the agency hasn't taken a position on that, Your Honor, and I wouldn't want to foreclose the agency from considering whether there's an alternative position. The last time that the agency looked at this question in HGG, it said, we think the statute is unambiguous at Chevron Step 1, but it observed that some courts of appeals had disagreed with it, and so it said, if we're wrong and the statute is ambiguous, we would reach the same interpretation for all of the same reasons. I think that this court's precedents say that in a case like that, the court will simply look at whether the agency's interpretation is reasonable, and if so, it need not decide whether any other interpretation is possible. And if I might just say one more thing about why I think that sort of judicially modest course is particularly appropriate here, it's because the court has recognized that in immigration law in particular, Congress has expressly delegated interpretive authority to the Attorney General, and the administration of the INA, and particularly something like this, setting the terms of humanitarian protection for foreign nationals, implicates foreign relation questions that really belong best to the executive.
Well, members of the court may have different opinions about Chevron, so are you saying that it is necessary for us to address Chevron here?
No, Your Honor. The court can simply find that the government has the better interpretation of the statutory text and say no more. And we certainly think that is the case for all of the reasons that we have discussed here today. Petitioners.
Well, if we say the government has the better interpretation, won't that foreclose you from later changing your position?
No, Your Honor, not under the court's decision in Brand X. The agency could theoretically decide that although it's taken a position, it has had this position since 1991, it studied the question further and concluded that the statute was ambiguous and that it should resolve that ambiguity by taking a different interpretation. It's possible the agency could decide to take that course in a future case, but I think it's not a question the court has reason to address now because the agency has an interpretation, and it's reasonable, but even if you didn't want to get in the Chevron framework, our interpretation is the better one.
Well, I really don't understand your answer. When you refer to Brand X, are you not back into Chevron?
I think the court's decision in Brand X recognizes that it is possible, theoretically, that there can be more than one reasonable construction of a statute. I think what we're saying is if you wanted to avoid getting into the Chevron framework altogether, you could do so by simply saying that our interpretation is better than the one that petitioners have reached. But the more standard procedure, I think, in a case like this, the court's precedents show, would be to ask whether the agency's longstanding and consistent interpretation is reasonable, and if so, it prevails.
Thank you.
Justice Sotomayor?
Counsel, I'd like to return to Justice Thomas's question about people who have traveled abroad, been given permission, TPS people who have been given permission to travel abroad. The Miscellaneous and Technical Immigration and Naturalization Amendments of 1991 provide that in the case of an alien who's given TPS, whom the Attorney General authorizes to travel abroad temporarily, and who returns to the U.S. in accordance with such authority, the alien shall be inspected and admitted in the same immigration status that the alien had at the time of departure. Says it right there, shall be inspected and admitted. By the plain text, it seems to me that any TPS holder who is granted permission to travel abroad and return would be admitted within the meaning of Section 1255. Yet you're telling me that the agency has said no in 2020. It makes no sense to me, counsel. You yourself argue that there's a difference between being between lawful non-immigrant status and admission. And if that's the case, how can you win on that argument?
Justice Sotomayor, the first thing to note about this argument, of course, is that petitioners have expressly waived it in this case. And as my friend explained, that's because the government's consistent practice before 2020 has been to treat the return from authorized travel for TPS recipients as a parole, and that, of course, wouldn't help them. Now, setting that aside, I'm happy to answer the question.
Well, but whether it was treated as a parole or not, we got to go by the words of the statute. And the words of the statute talk about it being an admission.
Yep.
So you want to recharacterize it as a parole, or I don't know why they forfeited it all, but other people may not. It just seems to me that if you're asking us to find the better reading of a statute, we should go by its terms. Those people have been admitted.
Justice Sotomayor, we think that the clear import of EMTINA, this statute, is to make the point that when a person who has TPS is authorized to travel abroad and comes back, they come back in return in the same immigration status that they had when they went out. And I think that is certainly the most natural reading of that text, and it's at minimum, it's a reasonable reading of that text.
Now, then we get into Chevron. But if we're going to go, as we have suggested, which is go to the better reading of the actual language of the statute, you lose.
No, respectfully, Justice Sotomayor, I disagree with that. I think the other thing to note about this argument, of course, is that it's outside the scope of the question presented because it only applies to people who travel abroad. And the question presented in this case is about the effect of granting TPS itself. But again, I think the clear import of EMTINA is to specify that a person goes out and comes back in the same status. And what that's going to mean for a person like petitioners is that they will return to the United States in the status of someone who has no lawful immigration status, who is present here unlawfully and is subject to removal, but because of TPS will not be removed temporarily during conditions in their home country. That's their immigration status.
I've run out of time.
Justice Kagan?
Mr. Houston, you said earlier that nothing defines non-immigration status to include admission. And when I said something similar to Ms. Saharia, she told me that 1184A does just that. So could you tell me how you read that provision?
Certainly, Justice Kagan. I think the purpose of 1184 is to specify the conditions that the government may use to admit non-immigrants. Of course, it's true that there are many, many non-immigrants who come to this country abroad and enter lawfully through a port of entry. They get admitted. And it makes sense that Congress in Section 1184 wrote a provision granting the service authority to set some of the restrictions and requirements for that admission process, and then imposing some of Congress's own.
It does seem, though, Mr. Houston, that these phrases like admission as a non-immigrant, they arise repeatedly in the immigration statutes, so that, you know, Congress seems to be assuming that non-immigrants are in fact admitted, and that the status admission distinction that you continually press on us is really not a distinction with respect to non-immigrants.
Your Honor, I think it is certainly true that the overwhelming majority of people who have non-immigrant status get it by coming here lawfully. And the fact that there are references throughout the INA and in the regulations and in the policy manual and things like that to people admitted as non-immigrants just reflects that reality. Most people come here lawfully, and that's how they get non-immigrant status. But it remains true that both as a matter of statutory text, and keep in mind there's a definition of admitted in this statute, and so I think as a matter of text, as a matter of ordinary usage, admission is a factual event. It's something that happens at a particular place and time. Lawful status refers to permission that the person has. And so there's just nothing
and let me switch gears a little bit. On your view, under what conditions can a TPS holder actually become a lawful permanent resident?
Oh, Your Honor, there are tens of thousands of TPS holders who have successfully adjusted their status to lawful permanent residence. People do this every year. The only thing
what are the conditions in which they can do it?
Sure, they just need to have come here originally and been admitted. They need to have been admitted as a student or an au pair or a temporary worker or something like that. Anyone who comes here lawfully in one of the non-immigrant statuses, except crewmen, would be able to demonstrate that they are here they have been admitted, and then even the TPS will allow them to stay here longer than their status would normally have done. And the purpose of Section F4 is to say, as you know, even if you were originally out of status, while you are being allowed to remain here, we will preserve your existing opportunity to adjust your status. It doesn't create a new opportunity.
Justice Gorsuch?
Thank you. I have no questions at this time.
Justice Kavanaugh?
Thank you, Chief Justice. Good afternoon, Mr. Houston. Just in terms of your position here with respect to how, if you were to prevail, the opinion's phrased, I think there are three options, and I just want to explore them with you. One, you argue that we could just say it's at least reasonable, your interpretation is at least reasonable and not unambiguously foreclosed. Second option is we could just say that your interpretation is the better one, not the unambiguously better one necessarily, but just the better one. And the third option is to say that your statutory interpretation is unambiguously the correct one. I gather you don't want us to say the third.
Justice Kavanaugh, we would urge the court to follow the first of those proposals because I think it's the most consistent with the court's precedent, although, candidly, I'm not sure.
I mean, just, you know, in courts of appeals, certainly all three of those options are deployed routinely and at this court as well.
Well, sure, Your Honor. I understand that. I mean, I'm not sure I see a meaningful difference between the first and second interpretation.
The first one, you wouldn't be saying it's the better interpretation. You're just saying it's at least a reasonable interpretation of the statutory language.
I think that would be our preference, Your Honor, because we think it follows most directly from this court's immigration preference, and because, you know, we think that the agency is the one who is charged with the administration of this statute. And if the agency, you know, we think the court generally does not foreclose the agency from thinking about the problem in the future. And so I think it's notable that under this court's precedents, petitioners have a high bar to clear. We think they haven't cleared it, and we think it's sufficient for the day for the court to say that.
Okay. How many people are in the country who are in this same status, roughly?
Do you mean temporary protected status, Your Honor?
Yes.
Just want to make sure we understand that there are approximately 400,000, although the government's understanding is that approximately 85,000 of them have already successfully adjusted to lawful permanent residence status.
One of the amicus briefs of the American Immigration Lawyers Association and others says that roughly 80% of those have been living in the United States for more than 20 years and have married and had children, authorized to work here. Do you dispute that?
No, Your Honor, we don't dispute that. But I think that it is the defining characteristic of temporary protected status is that
it's not temporary.
Well, it has turned out, I think, to last. Some of these crises have turned out to last for a while, and the United States, I think, has been extraordinarily generous, and it is a testament to the strength of our humanitarian commitments that we have allowed people who have found themselves stranded here during a crisis to stay here for a very long time. But all TPS recipients receive that status with the unambiguous awareness that it is a temporary form of relief from removal that will not last forever because the government has to continuously reevaluate whether the conditions in the home country persist, and moreover, the recipient himself has to re-register for the status on an ongoing basis. So everyone understands,
I understand that. It puts the people in a very awkward position year after year, and I'm sure you understand that, but I'll let that go. Thank you.
Justice Barrett?
Good morning, Mr. Houston, or I guess it's afternoon now. I want to follow on to the questions that Justice Kavanaugh was asking you about the three ways that we could write this opinion. And one thing I just want to start by clarifying, I think the Chief Justice pressed you a little bit on this. Is it correct to say then that the government has changed its position from the cert stage to the merit stage about whether the statute is clear or ambiguous?
No, Your Honor. The agency's position has been that the statute is unambiguous at Chevron Step 1, but in the alternative, if it's ambiguous, it would have reached the same reason. We're not backing away from that position, but we do think that the court doesn't need to reach that, and we think the court's precedents have indicated that the court won't foreclose the agency in a case like this from considering whether any other alternative is possible.
Okay, well then I guess I'm where Justice Alito was when he said he didn't really understand the difference between that position and you're asking us to give you Chevron deference. And I guess I also think if that's your position, how do we avoid addressing some of the issues that the petitioner raises about whether the interpretations that the government has offered here are even entitled to Chevron deference at all because they're informal adjudications, et cetera?
Justice Barrett, I think you could resolve the case if you were inclined to avoid getting into Chevron deference at all. You could simply resolve the case along the lines that Justice Kavanaugh's second option suggested, that the government has the better reading of the statute. That would be sufficient to affirm the judgment below, and the court could say no more. We would also be perfectly fine with the court saying that the government's interpretation is reasonable and petitioners haven't met their bar to show that our position is unambiguously foreclosed. Either of those conclusions would be fine with us because we think that they would affirm the legitimacy of the government's longstanding and consistent interpretation.
But you don't want Justice Kavanaugh's, I think it was his third, saying that it is unambiguously in your favor.
That's right, Your Honor. And just the reason for that is because we think that as a general matter, it is the agency that has been expressly charged by Congress with interpreting this statute. And we think that generally the court recognizes that because of that feature and because it implicates questions of foreign affairs, the court should not reach out to foreclose the agency from ever deciding a case.
Mr. Houston, just so I don't run out of time, let me just ask you one other question. Is it the case that U visa holders are the only non-immigrants who have not been admitted, or are there others? I mean, putting aside alien crewmen, are there others besides U visa holders?
I think that they are the only ones, Your Honor, and if I might just elaborate on that point for 1 minute, it's true, as my friend suggests, that you non-immigrants have been treated for certain purposes as admitted into the United States. The question in Garnicia Silva was about whether the grant of U visa status was an admission for purposes of a certain time bar in the INA, but if that, insofar as that's true, it's because Congress has created a special provision for them in Section 1255M, labeling some of them as admitted, and I think that just reinforces that Congress is aware of labeling a certain kind of non-immigrant as admitted, even though they didn't come here lawfully. And the stark contrast between Congress's drafting choice in that provision and the TPS provision has to be given respect, I think.
Thank you.
A minute to wrap up, Mr. Houston.
Thank you, Mr. Chief Justice. I'd like to just briefly recap the textual reasons why the agency's statutory construction is not unambiguously foreclosed. First is the definition of admitted, which petitioners concede they can't meet. Second is the direct textual parallelism between the two-part lawful status benefit in the TPS statute and the two-part lawful status requirement for adjustment of status, which suggests the TPS statute doesn't address the other requirements for adjustment of status, like admission. Third is the fact that the lawful status benefit is available only, quote, during the TPS period, which I think is strong evidence that it does not retroactively cure pre-TPS conduct that made the person ineligible for adjustment of status. And finally, are all the other places in the INA where Congress has expressly authorized various classes of aliens to adjust their status, notwithstanding their entry without admission. Petitioners haven't explained why Congress didn't follow any similar course for TPS recipients. And so the court need only hold in this case that for all of those reasons, the agency's interpretation of the statute was reasonable. Thank you.
Thank you, counsel. Ms. Zaharia, rebuttal?
Yes, one clarification. Government counsel referred to the tens of thousands of TPS recipients who have adjusted status. It is highly unlikely that those are the majority of those are people who entered as non-immigrants, because the vast minority of TPS recipients entered this country as non-immigrants. Those are almost certainly people who adjusted status pursuant to the government's prior position that re-entry on parole permits an adjustment of status. Now, with respect to the question of whether admission is inherent in non-immigrant status, when it comes to non-immigrants, those are not distinct concepts. A great example of that is Section 1258, governing a change of status, which Congress expressly cross-referenced in F4, the provision at issue. That provision explains that the agency may change a non-immigrant classification, quote, in the case of any alien lawfully admitted to the United States as a non-immigrant who is continuing to maintain that status, end quote. Congress there expressly equated the concept of being admitted as a non-immigrant with having lawful status as a non-immigrant, and that is entirely consistent with how that concept is treated throughout the INA. Now, I think I heard government counsel to concede that if you look in every tunnel and on every mountain in this country, every single non-immigrant, except for alien crewmen and U visa holders, are in fact admitted. Alien crewmen are the exception that proves the rule because Congress had to create an express exception for them in the statute. And as to the U visa non-immigrants who did not exist in 1990, the statute, which is Section 1255M, M1A, expressly refers to them as having been admitted. It permits adjustment if they have been physically present in the United States for a continuous period since the date of admission as a non-immigrant. I'm not sure I understood counsel's attempt to distinguish away the Garnica Silva case. That case did not just deem U visa non-immigrants to be admitted for one single purpose. It held unequivocally that they are admitted based on this language that I just quoted, the language of the INA and the government's own regulations. The only category of non-immigrants who are not admitted are alien crewmen, and they are the exception that proves the rule. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.